is not clear. So all those things become cause for dispute, and then admission becomes difficult. Then, of course, COVID period related debts are to be excluded altogether because of Section 10A, and then should not be an attempt to recovery, and it should not be pollution. So that's the application process, and prerequisites for initiation of CIR. Once the CIRP is started, management is suspended. So the existing management is suspended. IRP, that is interim resolution professional, is appointed. Moratorium kicks in, and all claims of all creditors are to be presented to the IRP, who is later confirmed or placed by the COC. That is, Committee of Creditors is formed through those people who present their claims. Once the COC is constituted, the RP can be appointed by COC or IRP can be confirmed. Then begins the process of inviting, evaluating, and selection of resolution plans, and that is the job which all these people who are sitting in this room they do. What is a good resolution plan? A good resolution plan, as in line with the preamble and the objectives of the Act, is to maximize value of the assets. That is the central objective. That maximization of value of the corporate debtors' asset should be done. Because the assets are already under stress. Before a company comes and the CIRP, even before the application has begun, application has come, the stress is there. And then when the application comes before NCLT, the stress begins, stress increases. That is the time when promoters and management realizes that their days are numbered. They can be replaced, they can be suspended. They themselves become contributory to the stress. And once the CIRP starts, maximization of value of those assets, it's a very, very uphill task. But that is what we have to do. A good plan will ensure that assets are not left idle or wasted, that they are put to either productive use or they are monetized efficiently. A good resolution plan will balance interests of stakeholders. Creditors, they should definitely receive their fair and equitable treatment. Workmen and employees should get their dues as per their priority. Government should be paid at least to the extent of that is prescribed by law, even if it is the bottom of the protocol mechanism, but still something, whatever comes in. Customers and suppliers should have confidence that their advances and supplies will not be lost. And finally, no class of shareholders should be unfairly discriminated against. These are standards. These phrases I have picked up from different judgments. Various judgments have used these phrases, and I have picked those phrases from there. And many a times, many of you have quoted these phrases to us in presenting those resolution plans. A good resolution plan should also ensure viability and continuity. The corporate debtor must continue as a going concern, generating revenue and meeting obligations. If it is generating, we have had some corporate debtors under resolution for more than 6 years, 7 years. Mr. Karmpati is sitting here. How many years you are handling that case?
3 years.
3 years. There's one more which is very old one.
That's the liquidation.
That is
Power plant.
Power plant. Which one was that?
Borosima.
How many years? Since CIRP?
5 years. No,
5 years?
No, CIRP is 7 years.
7 years.
Liquidation
Since CIRP.
Liquidation 5.
5 years. Total 7 years. Now, since for all these 7 years, plant is running. Plant is running.
No.
The plant is not running.
Thanks to relax that Andhra gas plants.
But there was another one where the plant is running and generating revenue. We distributed the revenue also. I do not know, I forget the name of that case. I was under the impression that
Power plant.
power plant. It's a running power plant.
That is KSK man.
KSK man.
It's
Yes.
a big one.
It's a running
Surplus
plant.
cash is there.
Huh?
Surplus cash they have
Surplus cash of almost 6,000 crores
Yes,
distributed.
they are distributed.
While KIRP itself.
Yes.
Then the other one, with hotel, that is also sitting on bunch of cash. It's a running hotel
Vice
under CIR.
Vice
Huh?
Vice
Golden Jubilee.
Marriott.
So it is also sitting on bunch of cash there, more than I think 300, 400 crores. So if it is continued as a going concern, that is the responsibility of RP once our CIRP has started. And he has to ensure that whatever plan comes, it should continue, it should ensure that kind of continuity. And then plan should be based upon realistic financial projections and a credible revival strategy, not merely paper recoveries. This is also another essential aspect of a good plan. Certainty of implementation is another aspect which a good plan should have. It should be feasible and implementable within the time frame given under IBC. Many a times we see earnest money is deposited, bid is made, the resolution plan is approved, timelines are not kept. We have had one particular case, I will not name that particular case, where after a plan or whatever after plan was approved, it was approved in 2019, and it is still not implemented because of some reason or another. Adequate provision of financing, approvals, and regulatory clearances should be built into the plan itself. How will they achieve? How will they receive those approvals and all that? Payments, disbursements, and compliance obligation must be clearly structured. This is, of course, given. Another important aspect of any resolution plan should be to hold the erstwhile management, which was responsible for the state of affairs, to bring them to account. There are cases where there are some cases where management did everything right, but the corporate came under stress for reasons of COVID, for reasons of not getting enough gas. For most of their gas-based power plants, when they did not get gas, 12 plants closed down. So everything right was done, but the corporate entity came under stress. But there are scores and scores of cases where the stress is directly attributable to the erstwhile management. And a good plan should take into account as to how the erstwhile management, how that management responsible for the stress can be brought to, can be held accountable through those, what we call, popularly we call them buffet transactions. Sir, preferential, what is that? Undervalued, fraudulent, extortionist. They all know buffet. And it's not buffet. Buffet lunch over. Preferential, undervalued, extortionate, and fraudulent transactions, buffet transactions. So these are the transactions which any resolution plan should account for and take into account how to get that money back. Of course, the resolution applicant should be a reliable and credible applicant and not someone who is disqualified under section 29A, which is essentially relating to the related parties. Many a times, the management which has lost the company try to come back through related entities and try to take over the same company, bereft of all the, because of that, what we call it, another term which we use very often is a clean slate principle. Once the resolution plan is implemented, all earlier views are extinguished. So that is what is called clean slate principle. So to get a clean slate, the same management which is responsible for the stress in the company comes back and tries to take over the company with a clean slate. So that has to be avoided. But we are saying that about 229A, that is related entity, but in the government itself has made an exception. A carve out has been made already for MSMEs. MSMEs are allowed to come back and aim to get the clean slate through CIR. Finally, a good resolution plan should comply with the law and fair process. It should follow the principles of fairness, transparency, and non-arbitrariness. And here comes the term which Mr. Ramesh was saying, commercial wisdom of COC is paramount, but it must still protect the statutory rights of the stakeholders. And plan must conform to section 32 and be approved by COC and MCA. 32, section 32 is it gives a whole lot of lists of what is should be there in the plan, and that is to be agreed. Before I forget, and you say ये तो छोड़ ही दिया हमारा, it's fair resolution cost at priority, because this is something which concerns all these insolvency professionals. ये नहीं मिलेगा तो क्या करें? So just to recapitulate, a good resolution plan should maximize value, balance interests of stakeholders. It should ensure viability and continuity. It should provide certainty and compliance with law, besides paying for resolution costs and so this is a good resolution. What are the impediments in good resolution? First impediment is delay. Delays and litigation. Admission delays itself sometimes contribute to the additional stress of the assets. So long as the application is pending and the management is reasonably sure that insolvency process will get started and they may get thrown out, they start stripping off the assets of the company. And if the company was at X level of stress at the beginning of the application process, by the time admission takes place, it is 20x. And that delay in admission process, we have seen cases where the delay can be up to 3 years from filing of application to admission. And all of us are responsible. Bench is responsible. And the councils are responsible. Management is responsible. Banks are also responsible who have brought those CI applicants themselves are responsible. So sometimes they're behind the scene negotiations are going on, and then settlement ho raha hai. And then they keep taking adjournment after adjournment. And sometimes we have to, from the bench, we have to insist, now this is enough. Either you want to pursue it or you don't want to pursue it. So these admission delays, of course, unless the matter is admitted into CIRB, there is no resolution. So that delay itself is an impediment. Frequent appeals keep coming with every small order, every interlocutory order. Every application comes up with more than minimum 2, maximum can be 100. One case in Hyderabad, I think, during admission process, I don't think any of the council of Hyderabad was left who had not filed an application on their behalf. He dealt with almost how many, maybe anybody can go. Yes, which one was that?
Yes.
लेकिन आपको पता है मैंने नहीं कहा. I don't say that. Every council work is solved was tested in that case to stall admission. It was an uphill task. It went on for almost 3 years. And appeals after appeals. Weak resolution plans, that is lack of serious bidders. What I call is a phenomena of, I don't know, it may not happen in this part of the country because this part of the country is reasonably prosperous. यूपी वगैरह में I hope everybody understand Hindi थोड़ा बहुत.
Yes.
Yes, sir.
यूपी वगैरह में यूपी रोडवेज की बस पे जो लोग जाते हैं, when you go, you try to sit on a seat, वहाँ पे किसी का रुमाल रखा हुआ है. और फिर वो जिसका रुमाल होता है वो आके कहता है, मैं रुमाल छोड़ के गया था, तुम यहाँ कैसे बैठे? लड़का.
Here also.
हाँ, यहाँ भी होता है ना, यहाँ CIRP में भी होता है. CIRP में भी वो अर्नेस्ट मनी डिपॉजिट देने के बाद, देन आफ्टर दैट अर्नेस्ट मनी दे दिया, बिड अमाउंट दे दिया, उसके बाद जो रिजोल्यूशन प्लान को अप्रूव करा लिया, उसके बाद घूम रहे हैं पैसा इधर उधर से मांग रहे हैं. रिजोल्यूशन प्लान का इम्प्लीमेंटेशन हो ही नहीं पा रहा है, एंड देन आस्किंग फॉर एक्सटेंशन आफ्टर एक्सटेंशन, one extension after another extension. Made a bid for 100 crores but paid only 5 crores. And वो रुमाल रखा है वहाँ पे. मैंने क्यों कर रहा था?
सब लिक्विडेशन.
हाँ, आपके पास वो रुमाल रखा है उसमें उन्होंने. Anyway, so serious bidders, and then another thing is happening. Many of these corporate entities, when they are going through stress, production stops, employees leave, factory starts dilapidating, plant and machinery gets rusted. It is of no value left. Mr. Gonkonta is sitting there. He is sitting on one case of that nature. So what is of value there left? Land. So the bidder is not coming for resolution. Bidder is coming for the value of the land. And that is, how can we call him a serious bidder? He is not resolving the matter. He is simply going to take the land and use it for developing some other project altogether different from whatever was being done earlier. But COC merely approves it. And as Mr. Ramesh said, COC commercial wisdom is supreme. He also bowed down to them, unless it is completely capricious. And what is the other word? Arbitrary. Put the words in. Unreliable financials. Again, these companies which are undergoing stress, they stop making, they stop filing income tax return, they stop paying TDS, they stop paying EPF. They are not maintaining books properly because employees have left. Promoters are only interested in taking out their own investment and somehow getting or trying to insulate themselves. So then there are no financials available. And we can one can understand the state of mind of a promoter who has built a company over 20 years when he is 20, 30 years, and when the company is he knows that company is going to go away from him. He is very, very agitated. And many a times we get these applications from all of you. Ask them to cooperate. How can we ask them to cooperate? We can ask them, but they will not cooperate. What will you do? They don't want to cooperate. At the most we can do what we can order them to cooperate, and then what can happen? You will come back and say, contemptuously jail. We will put them in a jail. Maximum jail we can give them 1 month. After that, once again, cooperation is still missing. So, these financials, unreliable financials are there. So, once unreliable financials are there, we don't even know sometimes what assets are there. Some assets will be hidden somewhere altogether, not there in the books. Companies have a factory maybe in Hyderabad, there may be a bungalow in Bombay, which is not mentioned anywhere. So, these kind of issues come up in implementation of resolution plans. The stakeholders keep arguing and disputing amongst themselves and bringing in various kind of litigation before us, and that contributes to delay. Eligibility disputes are also coming up again and again, and there is always an attempt for the erstwhile management to take back the company in one way or another, to the extent of generating false MSME certificates. Generating MSME certificate is a very easy process. Anybody can go to the the ministry's website, enter your PAN number and phone number, and you get MSME certificate. and present it to the HCLT. And since I am MSME now, now I'm not barred under 29A. We have seen these kind of cases. Lack of interim finance, sectoral clearances, regulatory approvals, stall implementation. That one case which I was talking about, because resolution plan approved in 1990, we are sitting in 2025. Party is willing to give the money. Creditors are willing to take the money. The corporate entity is running as a going concern, generating revenue, generating cash. Plan is not getting implemented because of the clearance to be given by government of Telangana. The government is sitting on clearances. So these kind of impediments also come. Oh, so when I was listing out all these problems, then I got tired. So what could be the solutions? So I asked Jackie. That's why I'm crediting them with what are the various solutions. And they came up with a whole list, beautiful list. And if you go through this list slowly, the list says all very nice things. And when I was going through this list, I was reminded of a prayer which we used to say in our school. प्राणियों में प्रेम हो, भाई भाई का भाव हो, बैर ना हो, कोई बैर ना हो, सब सत्य पे बोले, सत्य पे चले, सब में दया का भाव हो. You all can understand Hindi, na?
Yes.
All nice things should be there in all human beings. But if all nice things were there in all human beings, we will not reach this stage.
All Indians are my brothers. All Indians are my brothers and all Indians are my brothers.
Well, सेवा में जीवन अर्पण करें. Don't expect anything. सबके पास ज्ञान का प्रकाश हो. But look at these solutions. Finding credible bidders. I have already elaborated on that. Who is a credible bidder? The one who is trying to resolve the company, or who is trying to get the land, or who is just simply trying to put a romal on the seat? Who is a credible bidder? Transparent financials. Where will we get transparent financials? How can we get transparent? This is a problem. This is not a solution. These are the problems. And that's why you should not trust ChatGPT. Because they sometimes repeat the problems as solutions. Sorry. Then this informed commercial decision. This is really interesting. COC should take informed commercial decision. And most of the minutes of the meeting which we have seen here of COC, their only and only objective is to recover as much as possible. Maximum recovery. Barring one case where there was some kind of a hope of actual resolution without seeking recovery immediately. Other than that, only objective is to get recovery. And who sits in these meetings? There are some managers, some general managers, some PGM. Whereas to run a company, to take a commercial decision about a company, let's say company is taking steel. You need engineers. You need not only accountants, you need these valuers. You need professionals, host of professionals, who can sit down and see whether the company is a viable company or can be run properly. All maximum who comes on these meetings are these bank managers, or they are assisted by their clerks. Even accountants are not there. Engineers are not there. So, informed commercial decision is several times not there. But since COC is COC, they are the one who's affected. They have taken approval from their own higher-ups for distribution. They present it. And Supreme Court itself has blessed this position that financial creditors can be authoritarian. If they decide not to give anything to the operational creditors, that is it. So solutions are the problems as per ChatGPT. Coming to the last part and the real topic of ours of this session, let me once again go back to the headlines. Bankruptcy resolution have peaked in financial year 2025. Creditors recovered more than 67,000 crores. Creditors recovered again, Business Standard next day again said the same thing. This is up 42% from financial year 24. CRISIL reported that in 9 years of IBC, it has helped to resolve over 26 lakh crores of debt directly or indirectly. This is a big amount. But when they prepared this chart to show that IBC has been the highest recovery, IBC has the highest recovery rate amongst various debt resolution mechanisms, there they show the recovery of only 12 lakhs. 12 lakh crores. I don't know whether you can read it from that distance. But because this is the chart prepared, and it's taken from their website only. So 12 lakh crore was collected. The 12 lakh crores has been resolved. Income tax wali aadat nahi hai na, collected. Tax is always collected. So 12 lakh crore has been resolved. But there it says 26. So where did this 14 lakh crore go? That gone. Prime Minister also asked this question to IBBI, and then IBBI came with this answer. How NCLT has become terminal of hope, reviving assets worth billions despite resource crunch, and the amount mentioned here is over 30,000 cases worth rupees 14 lakh crores of outstanding claims were settled before CIRB.
That's true.
That is true.
Indirect is true. Prevention has happened.
Yes, and that has been the role of NCLT in revival of business. And that is what I'll say, that revival has been. We have acted in NCLT. We have acted like that traffic policeman who stands before the red light. Not after the red light to cut off the challan, but before the red light, so that when the red light comes, anybody who is thinking of crossing the red light will stop because I am standing. So that is the main role of NCLT in revival under IBC. And thank you very much for your patient listening. Thank you.
You, sir, audience have any questions? No questions, but I only appreciate, sir. Being an NCLT member, you are bogged down in so many cases. And thankfully, you are not a lawyer. That made you to give such a presentation. Because, sir, in fact, this queue is not only meant for FAPKI members, but to us also, it will be again. Not that I want to praise, no, it's come artfully, having seen this 5-6 years of insolvency. The pain which you took to bring the real points, we would like to really thank you and appreciate for it. Thank you. Sitting judge with so many issues are day to day. Doing this presentation as management expert is a real
Congratulations, sir. You made a very practical presentation. With enlightened us, no doubt. I have a very small point. Section 7, Section 8, and Section 10 of IBC deals with on the occurrence of default. And originally there is no Section 238A in the IBC for providing the limitation. On the occurrence of default is syncing with the main objective, that is maximization of value of assets. At time But 238 provides 3 years mechanism. And from DRT, after spending 5-6 years in DRT, coming with a recovery certificate, 3 more years they are taking, and coming before NCLT filing Section 7 petitions. So this is a travesty of justice, according to me. And also, judicial wisdom, which is not commercial wisdom alone. Judicial wisdom cannot be taken away by the law, because justice prevails ultimately. So, I have heard some cases where invoking judicial wisdom, where single creator having 100% voting rights, all through for 2-3 years, he has gone along with one single bidder, are already pre-chosen. Even they have bulldozed the resolution professional who wanted to give a fresh invitation for bidders. So this is again a lacuna in the system. And even some of the, I think, I'm not talking about your bench, Your Lordship. Some of the benches said that we go by COC wisdom. Even a single person having 100% voting, he has a commercial interest, not commercial wisdom. And there is a huge difference. Yes. And the original design of the act code is on the occurrence of default, so that the value depletion should not happen because of the passage of time. So this may be addressed by Your Lordship in your judgments. Thank you. Overall, you have made a wonderful judgment.
Thank you, sir.
See, when we hear the term committee of creditors, there's S at the end. The image we get in our mind is that there will be a set of individuals sitting around the table and taking a decision which will be commercially wise decision. That is the image we have. But oftentimes there is only one individual appearing on the screen in front of the RP saying, I am 100% creditor and this is my decision. There is no commercial wisdom, and as Mr. Ramakrishnan said just now, Dr. Ramakrishnan said just now, it is commercial interest, not commercial wisdom, that sometimes comes before us, which masquerade as commercial wisdom, which is pretending to be commercial wisdom, but it was only commercial interest. But that is there in all other cases also, where we have had a case just now recently, 19 banks involved. 19 banks, not 1, 2, 3, 4, 5. 19 banks are involved. And at the end of the day, they are only looking at their commercial interest. They are not trying to resolve. They are not trying to do anything which is wise. They are not looking into the interests of operation creditors. They are not looking in the interests of the government or the TDS which has not been deducted or deducted and not paid. So these you may say it a lacuna, but I'll say these bad faith decisions.
Their judicial wisdom is important.
Sir, either judicial wisdom, enforcement, we bandy out these big words. But any law is as good as the citizens want to implement it in good faith. If red light is there and you are supposed to stop, then it's a very simple law. Red light hai, rukna hai. But if nobody is watching, we try to cross. So we have broken the law. So all it takes is who is watching. Judicial wisdom is only that policeman who is standing there. When the judicial wisdom is not there. Not all judges are wise. I'm not as wise. I have told you already, I'm not even a lawyer.
But this created a word, wisdom.
Yes.
No way to define.
It is up to the citizens, up to the people, up to the stakeholders to abide by the law in collective interest. And what we call in economic terms is enlightened self-interest. If everybody follows the law in good faith, then enlightened self-interest will ensure that everybody will progress together. If we all stay in the lane, traffic will move, even though it will move slowly. But if we are all trying to cut the lane, nobody will be able to move.
just wanted to thank you. Quite a lot of unlearning and learning today. Rather than hearing you so wholeheartedly, and many points, not just the law, the difficulties of dealing with different situations, not coded, not regulated, and trying to keep the spirit of the whole act and making sure that everybody get a fair chance of revival and taking it forward. It's so nice to hear you, sir. One small question I wanted to ask is, background that you come from is very different. And then when you came on to an education and the fact that it's a very formative years now for IBC, because it all started a few years back. How do you deal with how do you deal with new situations, sir? Because every time when something new is decided, and unfortunately now very quickly it goes to the upper levels and upper levels. So it must be quite a task for you all also sitting and deciding something new always. And how do you balance the practicality of law, equities, and the approach of spirit of IBC, sir?
That is where your assistant comes handy. The good judge is the one who knows nothing. Because then he can apply his mind based upon the arguments presented before him. So when you come before us, there's another person who is standing before us, representing their clients, doing their job in good faith, and teaching us and telling us what is, and then at the end of the day, we are okay, as a person, as an individual, I am a technical member. We have a judicial member who is very, very judicious, in fact. And he is always able to bring that judiciousness in the orders. You must have seen in our orders.
Yes, sir. Both of you are the very good combination.
So it is that is why that combination is there. So I bring in the technical expertise, he brings in the judicial expertise, and you are there to assist us. And because of excellent assistance we get in our court, particularly from some of very young lawyers, and some of them are sitting here. I know that. Yeah, she's sitting there. She keeps coming to us, and we know when she's saying something that means something. Something is real. If she has to hide something, वो पता चल जाता है. क्या है एडजस्टमेंट मांग तो रही है लेकिन
आप ये पता है रुमाल रख के जानने वाले बनते हैं
वो पता चल जाता है. So if you are all officers of the court that way, and you assist us.
Thank you.
Thank you, sir. Had an excellent presentation and patiently took up some newspaper headlines also, and how resolutions have got initial period and how the scheme of IBC gone through from last 2017 to 2025. And before saying the vote of thanks, sir, I have one small in my mind, sir. As you made in your presentation, which is the good resolution plan. So you have made out some points and what is the revival of intent of the applicant to revive the business rather than interested in the land. So, so far as my knowledge is concerned in the IBC, there is no such provision after the approval of resolution plan by the adjudicating authority and after making the payments to the creditor. What is happening to those resolution plan, whether the applicant intent as per the resolution plan, he is implementing the resolution plan, or he is taking the assets of the CD in a different way, or indirectly promoters are coming into, again the defaulted promoters are coming into the systems after 6 months or 1 year. So there is no such mechanism to examine what is happening after the approval of resolution plans. That's what I found out in a lot of cases. So what is going to be happen in that cases, because there is some sacrifice from the operational creditors, and even the governments also has been sacrificing their this one, and even financial creditors has recovers a small portion, or maybe they took their cut of 80% or 70%, whatever. All these sacrifices has been resulted into revival of that CD or not as per the intent of the resolution plan. So that's what I have this one, sir. And other than that, you say that I have not covered anything, but your presentation has covered the entire scheme of the IBC since application. even we have touched upon the chat GPT also, being a technical member, we have used the technology also. So I would like to
Cartoons were made by that.
yeah, heartful thank on behalf of IPA and IPNet and FTCCI sir, and also on behalf of the audience for making this workshop as graciously, and your presentation is an excellent presentation, sir. Once again, on behalf of all of us, very thanks to you for coming here, and thank you very much. We'll take a short 10 minutes. After that, next technical session will start.
May I request all of you to please assemble for the next session, please? I request all the participants to please come inside and settle down. We are going to start the session. May I once again request all the participants to please assemble inside the hall and settle down, please. It's my pleasure to invite Mr. Vikram Pusarla, sir, Senior Advocate, Civil Law Chambers, on the dais. May I ask Ella Rao, sir, to please accompany him to the dais. May I request Mr. Jitendra Rao, sir, to please come and give a shot to our speaker. May I request our MC members, Mr. Srinivas and Murthy sir, to please come on the dais and felicitate the speaker of the show. Thank you, Murthy sir. Thank you, Srinivas sir. I now request Dr. Ella Rao to please take over the dais and introduce the speaker and carry the session, please.
Dr. Mark. When I want to introduce Mr. Vikram, his profile shared by his staff or team members is also so simple like you mentioned. In fact, I want to introduce extempore with my 25 years relationship with him. Where I used to see him, though it was profile talking about the mergers, IBC matters, but I know his expertise in mergers and amalgamation and his appearance before High Court. Last but not least is human touch. I know one case I was representing and coordinating with him on behalf of my friend. He was very open and is in consults to the people. Keep aside the court matter and case matters, but he gives a courage. Nothing will happen cool. Like the
he handles with human touch that rarely happens. Which made it there with so many professionals. He is one of my among them. That is the one masterpiece which I just want to acknowledge. Now coming to the IBC, we know that he regularly appears before NCLT and NCLAT as well as High Court, but he contributes to the society at large as well as to the regulators and also to giving information. We can talk more since our result is already cautioned. Just introduce in 2 minutes. I'm closing. Closing with the curtain is the topic. The topic is capital reduce. Our technical members so aptly presented one of the concept, the clean state policy, which we expect that, especially IBC, if you see, always, the one of the dialogue is said, government, though given back seat, it knows how to collect the taxes or any other, maybe GST or anything, it will come back to them. The reason for the government to sit back is, yes, ultimately, if you see, I should not compare with that. If you are in the ground of any person, jitna bhi room go, ultimately you are come and end with that. If you like, horror movies, the person will room and ultimately he will come and sit, ghost will be there in front of them. I'm not saying central government or state government is a ghost, but ultimately when you are in the ground, end of the day, without government, we can't go back. So coming to the statutory dues, if you see the judgments, it may be Rainbow Industries or it may be PF case of Jet Airways Limited, whatever it may be. End of the day, PF case is one exception, above 53 we are talking, rest of the things are coming under 53, but the post impact after the submission of the successful resolution plan, what is the fit of SRAs, even for that, from the income tax angle, so many judgments are emerging, even the treatment tax, capital reserve and other things which we discussed yesterday also among our peers. This is the concept. So this statutory reduce is the one of the success and the key element, because without SRAs, there is no IBC, to be frank. There should be a successful resolution applicant, and people are approached to IBC like Agnipurita, how the Sita will come in with the things we expect from the IBC companies which are required under IBC is a clean sale. There are no dues and no pending dues, and only future will be there. But past legacy on going concern basis is attached, and this was built upon by so many NCL and CLAT also. Let's hear from the experienced senior advocate, Mr. Vikramji, from here. Over to Mr. Vikram. Thank you very much.
One and all, I definitely take a privilege of standing before you all. For the reason because on a regular basis, I see each one of you all performing very well individually and working from law. And even, as good or more than many lawyers in the present day case. So your preparation is very good. Your appreciation of law is very up to date. And your presentation of facts is also equally very nice. And, speaking there today before you all, and I was also told by Malik that regularly you all meet and you all debate discuss various issues of law. Like they say, law is a lifelong learning. So coming from there, the whole concept, earlier speaker has literally not left anything to speak or did not leave any kind of doubts in the minds of the students, I would say, because I'm also a student, I was sitting there. He literally covered everything. I thought the session was over after that. There was nothing much to take it forward, but having prepared and I will give my example more illustratively than the topic, because cases you all know, the law is much clearer today, and therefore it is not the tribunals or courts or any superior authority who can turn around the case or turn around the issue depending on how they're presented to you. Then some of them who I feel come from the time when I started practicing, not before that. I came into practice in the year 2000. So some of the seniors who I see here practice much before that. So when I came into practice, the first thing that I took over, or I may say that to lack of choice or know what is the choice, I started working on company matters. And company matters way back in 2000 and 2002, there was a very nice phase, a lot of mergers and acquisitions that were going on. I had an advantage of doing the first cross-border merger in India. I had an advantage, privilege, I would say, that working with a former High Court judge, 50 years of standing, to give an opinion to a client to say that, okay, how is it possible that you merge an American company to an Indian company? There was no law on it, there were no precedents on it. So 2002, when I started from there, it was very interesting to know that the 1956 Act, the earlier Act which we had, was a very comprehensive Act. It survived for a long time. So we finally gave an opinion to this American client that merger can be done in the existing framework of law what we had. And like they said, everything fell in line. The Honorable Court, which heard the matter without any precedents, came to the conclusion that the definitions of transferee company are very different way back in 1956. So they permitted the merger to take place. Thereafter, a couple of other mergers took on. During that period, I used to regularly appear in the company code. That was where I used to appear most of the time. I had a chance of doing the other applications for director. Then I had a chance of doing a lot of matters for actually claims and authority, crown debts, and many judgments were came at that point of time from Rajasthan High Court, Supreme Court, whether it was more on the aspect that whether it's right or wrong to take away and close the credit, in particular the statutory dues. Government being above everything else in terms of being having a right to claim this amount. As the time went through, 528, 529, 530 of Companies Act, and without much of a clear clarity on which way the court should move, limitation and other things. Finally, when we came into the 2013 Act, when it came into 2013 Act, from 56 Act, then there were changes in 2013 Act. Then when we came to IBC in 2016, the point of contention was there was enough material before the Parliament to consider how they have to consider different claims and creditors and all. So I just felt that there's nothing that can truly reflect what's in my mind than this small 2 lines that I've read, and I felt it's very apt here. That is, to revive life, not in carrying the weight of the past, but in giving the future a fair chance to begin afresh. So when IBC came in, it is not on the aspect that the past will hold you back or past will pull you back. But the existing companies and the infrastructure which we already built and the liberalization and private equity that came into our country slowly after 91, whether we have the same old methods of the SARFAESI or REDB acts, or we come forward and give an opportunity for these industries separately from the promoters, separately from the bank, separately from the infrastructure to grow cleanly from there, whether it's possible or not. When IBC was brought in particularly about, I'm focusing only on the statutory dues and others, how they have to be treated. Maybe Parliament in its wisdom, I would say very nicely felt that equality should be there in among the creditors in terms of when their claims and how they are being treated among many. So in their own wisdom, they just felt that the statutory dues also should not be considered any different than others, except than regulated by the statute. Because when 2016 came, one of the things, you all are extraordinarily might have gone this a number of times, but just putting it in 4 points, maybe I've always prepared myself to put it in few points. One of the most reason for IBC was one place and one resolution. It was impossible for somebody to come forward, take a company, again go to another lawyer, file a case before a regulatory commission, get a regulatory dues decided somewhere else, customs somewhere else, income tax somewhere else, and then still hope that the budget that we have will allow him to plan and go forward. The whole concept, the statutory dues and all, I would say that one place, one resolution was very critical for somebody to have faith and believe that they were able to start something new and move forward. And above everything else, changing situations require change in thought process. Changing situations require some new things to come forward. And the second most important thing, the whole object behind the new legislation was to benefit the secured creditors in whichever way you feel like. Earlier speaker very rightly said, the government has many ways of collecting amounts, not just the dues. And then mostly, without blaming the government of not collecting it in time, the dues the government sits on is a long period. It's highly impossible for somebody to come back and say after 6 years or 5 years that okay, fine, we'll go forward and we'll have equal right today. So therefore, they said benefit should be given to the secured creditors among all of them. They've chosen them. So whatever time they fought for it. Then coming to the catchword, the clean trade theory. Ultimately, if you don't have somebody who will come forward and take or build the capital to move forward, there is no way anybody would come forward and take all these liabilities. Then the spirit of the code, anyway, you all have known that. So 2016, when the code was brought in, by then already we had 50 years of issues that ran from 1956 to 2013. Then 2013, there were some other changes that were brought in. In 2016, consciously, I would put it consciously, neither an accident nor out of ignoring something. Consciously, the legislature felt that they want to treat people in this manner. In liquidation, what they want to get, put them in the similar kind of the measure was 53. But they said in CRP process is what we want to treat you, whether in whichever way you would do. Until there was no clarity in the statute about how they want to deal with it, the whole dream of starting something new and allowing it to move forward wouldn't have been possible. Now, having said that, one of the things that most of y'all, the whole issue is part of from the concept of the earlier days, the whole concept of grounded concept itself came on a need, on a law of necessity and public policy. The earlier law, which has no more relevance today. But today I feel there's no necessity, there's no law of necessity today which can be brought into force for the purpose of putting statutory dues above everything else. The very fact that by the time the company is in a very shaky condition, if it's a core industry, which most of those companies are, which go into IBC, or service industries like hotels or hospitals not go into IBC, they're all manpower-driven industries and very dependent on what governments have to support in them locally in terms of regulations or collections of duties and all. Since those regulations and other statutes don't have a very strong mechanism of collecting dues on time, though individually, I would strongly feel the statutes individually don't have to wait till the company goes into IBC. They have the means and mechanism to regulate, mitigate, and control their outstandings. So, therefore, since they have a different statute to run, government in the wisdom felt that they would be treated in the same manner when they come to payment of debt at the final stage. Coming to the core issue, like in section 5 of section 21, which had defined the operational debt to include statutory dues, taxes, VAT, GST, and customs are operational debt and not financial debt. The role of operational creditors in CIRP also has been clearly carved out. What are the rights and what are the liabilities, and to what extent can they get anything. So, therefore, the test, like you all know, is whether they will be paid anything, whether they will be paid less than what they would get in liquidation. If the legislation wisdom has felt that they would VAT and taxes also would be put into the definition of operational creditor. So department today coming forward and making a claim, which two of the cases which I'll leave one of the cases went to Supreme Court Bremo papers, they clearly felt that the fact that there was no need, not only the definition of operational creditors, even under 53, the legislature was very, very clear that they are going to stand in line with all others. They won't be having any separate treatment for the purpose of claiming their dues. One of the first precedent which came in terms of which was reconfirmed by the court, if I have to put it like this. The NCLAT was the judgment of Synergies Dure Automotive Limited. You all, I'm sure you all be knowing the fact of the case. The dispute arose during the CIRP period. Again, the companies, including Synergies Dure, Income Tax Department and Sales Tax Department of Maharashtra challenged the resolution plan approved by NCLT. arguing that statutory dues like income tax, sales tax, and VAT should be classified as operational debt under the IBC. They consider that treating them as operational debts and reducing and restructuring them in a resolution plan were against the mandate of tax laws. NCLT approved the resolution plan. Treatment stating dues like income tax and VAT and operational debts classifying tax authority as operational debt. NCLT dismissed the appeal filed with Income Tax and Sales Tax Department. It held that statutory dues arising under existing law payable to central and state government have a direct nexus with operations for corporate data and hence fall within the meaning of operational debt. Findings of the court finally they said that it falls within operational debt. Having said that, then the one of the next case. So the court once again confirmed that they fall within operational debt. They cannot get anything more than what has been defined under the court. Then the next case that fell for consideration was the Sundaresh Bhatt, liberator of IBC shipyard versus CBIC. That's a 2022 case. The case arose from a conflict between security and government authorities regarding priorities of claims. IDB as a security had initiated recovery proceedings against the corporate data. The Central and Customs Department also raised demands for statutory dues, claim priority over security charged in the company data. This led to litigation concerning whether government dues under tax laws and precedents over laws of security data and the recovery of debt dues and financial institutions and surfacing. NCLT dismissed the petition of IDB by holding statutory dues payable to central excise were recoverable as government dues and an overriding effect. NCLT can appeal. The appellate authority appealed that NCLT's decision retrieving the tax authority's claims could not be defeated by security data. The appeal was dismissed. Supreme Court, rightly so, set aside the findings of both NCLT and NCLT and the security data and the surfacing and RDC have priority over government dues unless a specific statutory first charge is paid to the parliament. The appeal of IDB for the authority. Supreme Court said the government dues like excise or customs do not automatically get priority unless the statute expressly creates a first charge. Then surfacing RDB Act gives security data priority. Claims prevailing over tax dues, allowing banks like IDBI to recover first from secured assets before the government account. Before going to the rainbow papers, one of the things that I was contemplating while I was preparing for this is what happens if government is also given equal importance or views of the statutory bodies are given equal importance, like a secure data. What would go wrong if we give those importance to them? Would anybody like to say something about that? Because this arises out of once a plan is approved, money is put before. Thereafter on distribution, the issues on distribution, issues not on whether somebody puts a better plan or a higher plan or a lesser plan or more money. Issues in the order of priority of who's going to get how much. I mean, the user of T, this table first, that table second, and this table third. Similarly, if the dues are considered, the statute dues are considered to be taken equal to the dues or in priority to be paid. The question of payment in priority. What would happen if those dues are paid on priority? Anybody would like to?
Maybe the 1956 Act and the earned BFR provisions would have proven to be bad experience to the government. Number one. Number two, government was very eager to evolve ease of doing banking globally. Therefore, they want to take a heavy beating. There are the two reasons why they prefer them to get the last of the what online. It's just my point. And I feel that during their experience, when I say during BFR regime, it was all bad experience. Though they were ranked first in terms of realization, but they were not getting any money at all. Things are just prolonging in the courts. Perhaps that is the reason. Anyway, we are not getting. Why should let us, take some, fictitious sacrifice?
And anybody else? Why should government use not be considered like financial creditors use or in order of priority? There should be some reason for that.
Maybe
economy.
financial creditors accounts are coming from the depositors. So with the depositors are sacrificing by
That's one thing. Another thing, it's back on track. Again, they can earn their revenue through taxes once it's back on track. So they want to sacrifice and showcase others that.
Government looks at ways because of the country is running.
To support the banking system. Because credit of them is the biggest problem. If government use once a week company, comes into operation, they will get. future business. Maybe that is the.
So bank safety system and government can also recover. Malik, is such a
Taxes are fiscal in nature, not contractual. And by operation of law, they have a right to directly to recover that tax. But it is not an input. It is an output tax actually.
yes.
So, if
what you're saying.
if the prospective resolution applicant is burdened with that, you will save him away. And the ultimate purpose of IBC will be different. And of course, we have mentioned this case of Supreme Court 21. Clean slate policy. They said that the successful resolution applicant should not be burdened with all these things. We should start with a clean slate. So that the object of the IBC will be achieved. So in that, because that law also passed by the parliament, even the tax laws also passed by the parliament. So we have to harmonize these two.
And tax will be recovered, harmony, and then banks ultimately, because depositor can take money from public depositor. Therefore, that definitely a very valid point. Malik, you were saying something?
See, companies running automatically government rules are going to arise either because of profits or maybe because of the transactions. So that is where maybe the government needs to set the other operation traders in financial business. They are not going, the debt is not going to arise unless if you will start the transaction. Particular government uses automatically it is going to arise once the business either reviewable or maybe during the operations of the company.
Sir, what happened?
It's not like that. Government is not a creditor. Per se, the status is not a creditor. They are out of the profits when we collect.
I would say they are a beneficiary of somebody doing business.
Yeah, that's creditor, neither they provide any service or goods to the corporate debtor nor giving any loans to the corporate debtor. Provided out of the profits they collect revenue from the So it's not really profits.
Inactive part of it.
It's a charge, a statutory charge.
So I was just
See,
thinking
if the unit is established, then the government will collect from the profits. For establishment of unit, the financial institutions, they are advancing the amount. So they are having a priority. Without bank advancement, there is no collection of the revenue for government. That's the way banks finance, they have given a preferential benefit compared to the government.
The sort of investment.
since I was thinking when Malik told me to think about it, I was just trying to understand. I was asking all my colleagues also. Tell me one reason you got a tall man, short man, bald man, with hair and all. Why should this government suffer not being equal to the bank? Banks are branch arm of the government. They're not different. They don't fall from the sky. So banks are regulated by the government. In a sense, not directly, sir. What I meant was banks are controlled by regulation of the government.
You mentioned very correctly. Government is not a creditor in that sense, you know. And it is a sovereign. So if sovereign is kept as sovereign with the sovereign rights in this process also. But as well said, it is dead before beginning because nobody else will have a chance. But everybody only after sovereign is fully satisfied, then only the others come in. No, in India, as it is sovereign is forbearing. And use run to. And look at it.
Remote connection with the Article 13 and B.
Yes, sir. So what I
Socialist.
There is one more thing. You know, among all these ecosystem stakeholders, you see, government is the least efficient.
from here I can't say that. From there you can say that.
I'm also I'm part of the regulatory system, so I should not really kind of talk in those terms, but I think we have to accept that in this ecosystem, consider all the stakeholders. Government is the most nebulous or not nebulous, is not the word, the largest and least efficient. People can come up after 10 years, the claim. 20 years. Or 20 years. So if sovereign is kept as sovereign, with sovereign rights with this, government, the rest of them are small pygmies. I mean, they have no rights at all because they come lower in the so I think it is a very conscious, great, noble decision by the parliament to kind of, denied themselves the sovereign the right to come on top. Because sovereign comes on top everywhere, no? Anywhere sovereign comes on top.
Sovereign anyway is on top, sir.
Exactly. So
It's sovereign.
great. So my submission would be, please don't open it. Please don't put it in the minds of the lawmakers that you're the sovereign. So then you should exert your right.
Sir, companies concerned to IBC, HM and IBC are not, regulators. So government is giving some temporary sleeping period, that's all. Not waiving of its rights and not. Government know when to collect those.
So, coming back to the point, since I was thinking
Temporary period,
about. Yeah, coming back to the point, since I was thinking as much as all of you have given me different points to think. And just to sum up, some of them said that in the food supply chain, banks come first. They come when nobody believes in the company. They come and put a lot of trust. They fund the whole project, so they take it forward. They walk with the promoters for a longer time. They walk in the difficult times, and they try to hold their hands for a longer time. So definitely they should be given a little more opportunity, because without them, nothing else will come forward. There won't be any operational data, there won't be any tax, there won't be anything that, if I have to put it, the circus won't start without them. So yes, in that aspect, yes, you should give them a highest in terms of order, because without them, there won't be any direct, indirect, so many ways of economy to boost. So therefore, I believe that that's one of the reasons why maybe the parliament felt that you should give them that importance. Then again, ask myself this question: there were already two acts in their favor. There was the RDDB Act and there was the SARFAESI Act, and those two acts were in full force. RDDB Act was more in a form of a soft touch. SARFAESI Act was in the form of a sword and cutting thing at the right time when it didn't work. And both these acts were in place. What was the necessity to again put them back on top in IBC? Those acts are not repealed. Those acts are also there. So you had two acts. Again, a third kind of option was given. So according to me, they had three options. They can use either a benefit, or they could have used all of it together also. So therefore, coming to that, one of the things I said that if they would have been given the priority in the 2016 legislation, they wouldn't have had any interest of taking anything forward. See, they were anyway doing something out of the court by SARFAESI proceeding. They were only like a hammer and a bar. They knew only to, if the something was not good, they only knew to cut it and not even change it, cut it and take it from there. So the statutes, what they already had for recovery of dues, were only limited to the extent that there was no revival in those things. There was only aspect that if something doesn't work, break it open, sell it out, move from there. So their interest of doing anything in terms of company, or their active participation of deciding what is good for them, what is good for the industry, and what is good for the economy was not there. They were not an active participant in that. They just had to do a first aid service. The earlier acts, which I strongly believe, did not meet the requirement of what Parliament wanted. Parliament just didn't want somebody to recover and go. They wanted somebody to keep somebody alive also after that. So I strongly believe 2016 Act, when it came into force, they felt that we should give them importance on top of everything else. They've been struggling with recovery. They've been struggling in spite of a strong SARFAESI Act. And they've been struggling fundamentally in the issue that everything should come to one place and they should be the ones to decide, keeping the spirit of the act, keeping the spirit of the industry that they start also, that even if they recover, even if they give them the confidence that they can decide what is good for them, the most important thing. They can decide what is good for them. Here under IBC, they decide how much to take, what they can leave, and what is practical. In SARFAESI, even that option wouldn't have been there. Who was going to bid, who was going to put forward, only that mattered for them. So therefore, keeping this in mind, parliamentary wisdom felt we'll keep them in top priority. Let them decide, let them run this whole system. Let them choose what they want to leave, and we'll give them the protection in law to move on from there. So therefore, I strongly believe keeping these things in mind, and already two existing acts were there, they gave the secured traders or the financial institutes the complete power to deal with that. Having said that, governments and statutory dues being on a very independent footing, they all have their statutes which are running for them to recover those dues, monitor those dues, and and from time to time make sure that dues don't pile up. So keeping that in mind, because banks have only one thing is to recover. The other statutory acts which the dues can be controlled is to make sure that the company also runs and they also recover on time. So it was quite a balance, if I have to say, keeping the government out of the priority in the IBC. In my humble understanding, was a very nice balance for the parliament. I strongly believe that this has allowed the revival in so many ways. Now, coming back to the case of rainbow paper, to make it more interesting than parrot reading, which I don't want to do, I would like to divide this group into two. Who are the ones who actually wanted to support the judgment of rainbow papers that passed the Supreme Court, and who felt that Supreme Court shouldn't have done that? Anybody who runs for support of the judgment can raise their hands, or anybody who felt that Supreme Court shouldn't have done that. Anyone support of the case? Does anyone want to record it and send anywhere? So you all support the case, you all felt that Supreme Court did it very early, they shouldn't have done that. It leaves a little doubt. The bill is anyway on the way. So, having said that.
But this is live stream.
Rainbow, to strictly go to the facts of the case. There, prior to CRP itself, as per the VAT Act, they took the charge on the assets of the CEO.
Yeah, I come to that. See, fundamentally, IBC being a subsequent act, rainbow papers is a short and simple point. There are only 2 points in that. One of the 2 points is self and NCLT consideration. One, there was a due of more than 47 crores which was pending. And by the time they made their claim before the RP, it was belated claim. So that was the first point. Second point, they also made a claim saying that we should be treated separately because we have a charge on the property. On those 2 points, NCLT dismissed it. Finally, when the matter went to Supreme Court on the interpretation of the IBC provisions, in particular the security interest, that's what changed the whole case. The Honorable Supreme Court was interpreting the provision of security interest. It felt that it falls within the definition of security interest. I'm sure you all might have read the definition of security interest. I'm just reading it to have a different view of it. Security interest means right, title, interest, or claim to the property created in favor of or provided for a secure creditor. I'm underlining this portion now. By a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, encumbrance, or any other agreement, arrangement securing payment or performance of any obligation of any person, provided security interest shall not include a performance guarantee. So, the Honorable Supreme Court brought in the charge which was there in Section 48 of the GVAT Act for the department into this definition of security interest, reading it as it is in law a transaction which creates a security interest. So therefore, bringing that definition into security interest, the Honorable Supreme Court said they have a priority, you should treat them differently for a simple reason, because the charge is created and they are security interest. That falls under the definition of secured creditor. So therefore, you please treat them. And one of those, the last paragraph, which mostly cited in many cases, which says that if the secured creditor or statutory dues are not treated well, or treated appropriately, or treated by the POC, then please reject the plan. I'm sure you all might have read that part of the judgment also. As observed, we are constrained to hold the appellate authority and the speaking authority heard in law in rejecting the application appeal to the appellant. As observed above, delay in filing a claim cannot be a sole ground of rejecting the so and so. However, the judgment and order will not prevent the resolution of claim. So they simply held that if it is not treated properly, you please reject the plan. In my humble opinion, this may be an extreme view that has been taken, that any statutory dues which have been rejected, you please reject the plan in total. This carves out another ground for rejecting the plan which otherwise is not mentioned in the statute. So, because Supreme Court has said this now, on a daily basis, I am dealing with some of those statutory claims that have been made now before different forums, where workmen dues, customs, all those things where they pass orders after the plan has been approved on the ground saying that this is shown in balance sheets, this is shown before, though contingent, we have correspondence. Therefore, please consider them. There are a number of cases, and recently another case on customs, the Honorable Supreme Court said those dues are gone, they are extinguished. You can't reopen them. So, the rainbow purpose definitely it can be debated on both sides, saying that one of the arguments that can be taken, if I am arguing on that side, I would definitely say that the letter of law need not be considering other parts of equities and all. Letter of law is very clear. This is how it is. GBAT Act has a section 48 and security interest, it falls under the definition. I would definitely say the courts only interpret and implement the provisions of law. They don't write or do something different. So the courts were right in doing it. If we have to argue on the other side, we would say the whole spirit of having the IBC would be taken away if we bring them into the door by backdoor methods, or the interpretation given, the transaction can be defined and deemed to be transaction as defined under that particular provision is not a correct interpretation. If statute wanted, they would have done it rightly so. So, rainbow papers can be explained or argued in sessions like this on both ways. I would definitely consider to read it more, the spirit of IBC, and to make sure that nothing changes the way the whole thing has been arranged.
Sir, in rainbow paper, government also thought that they want to be in the talk, not as per 53 in the law. Based on their arguments, the Supreme Court has arrived that.
Yeah.
See, government also not saying that no, we are already as per 53, we are sitting on the last and we don't want to go outside. But in that case, government has fought very well saying that no, we have a charge and we wanted to take as a secured creditor on par with the financial crisis. So based on that only, Supreme Court has delivered that verdict.
Yeah.
Pachchimanchal have slightly diluted. Pachchimanchal with it
Pachchimanchal. Slightly diluted city views.
Yes, to the extent of, just to sum up, statutory views and the view I would like to definitely take a balanced view of that. They have the remedies, they have a statute, they have recovery mechanism. So to the extent the statutory views are concerned, the way the legislature has set it, in my humble opinion, is a very balanced way to push the financial creditors, secure creditors, including the people who come forward to run the companies, to take it forward. The extreme view, considering the fact that these dues have to be recovered, the government won't be in a position to run or will hit them and all. My humble submission will not happen because, like earlier speaker clearly said, governments have many ways of recovering taxes from the citizens. When overall interest of IBC, the way the legislature set the statute is a very appropriate way and a balanced way. Thank you for everything.
Actually, I not get that they have given a preference. Just my colleague told me. But banks are financing public money. Reason why they have given a first preference. The government dues are not public money. That's statutory dues. Just my friend, my colleague is telling to me. It's not my personal opinion. My colleague told me that the financial banks and are financing the public money. That's the reason why bank financial dues are having a preference over the other government dues.
Definitely, sir. That would have been
That is the
reason.
That's why we are both discussing your point.
That may be the right view also.
My colleague's view is maybe correct.
It's correct, sir.
That was a wonderful session, Vikramji. I'm just thinking, what is the meaning of Vikram? And I got answer in the Sanskrit is a straight and a straightforward. So he presented the entire speech straightforwardly, taking back from the history of the Savages today case to where the state government used fighting and made every audience to participate in what is the logic or object behind or philosophy behind the way the central government sacrificed by taking that seat. You have done splendidly, sir. Thank you very much for your presence. May I request all audience to put your hands together. Thanks, one and all, for each and every participant for your active participation in this session. You made supported Vikramji very well with your kind participation. So I do appreciate all the audience for your presence. Thanks to you, all of you. Over to organizers for other proceedings.
Thank you, Vikram sir. Thank you, Dr. Ella. May I now request Mr. Pawan Kankani, Secretary of ICSI Hyderabad Chapter, to please come and present a memento to Vikram Kusala sir. Thank you, Pawan. Before we move forward, there are two card numbers which I'm announcing. I suppose they are in the way, so you need to remove them. One is some AP91001. Quite a number. 1001. The other card is 2715 or 2215 something. TS13. May I request the owners of the car to please, or the drivers of the car to please take it away from there. And now, I request Mr. Narasimha Prasad sir, MD of IPA to address the gathering for 10 minutes, sir, please.
Yeah, 10 minutes.
10 minutes.
Thank you.
Thank you. We recognize the presence of Mr. Ashish Magicha, sir. Thank you, sir.
No. That's very nice of you to say that. But the reason I wanted to come in front of you again is that I thought we'll use this opportunity. So many IPs are here, so as many IPs are here. So that I would like to hear from you if there are any issues, or if there are any concerns, or if there are any things that you would like to convey. I thought we'll use this opportunity because I was here. Yeah. We'll keep it for 10 minutes. I want to hear you. I don't want to say anything there. Yeah. Yes.
Can I come and use a mic, sir?
Yes.
Well, great. So first, my session is after lunch. But I think what Mr. Narasimha Prasad is saying is absolutely right. This is an opportunity to interact with the regulator. Because on WhatsApp groups, we always criticize, this is not being done, that is not being done. Here he is. We want to hear from you. I think we should be very open, not very critical, of course, but whatever problems we are facing, like even filing of forms, regulations, monitoring, whatever is there, I think he will convey, he will take our message, and will try to sort it out. And I found him to be absolutely amenable, absolutely communicative. And I think they are standing for this. So please come out and ask your questions, please.
No, I don't want to use it to your time, sir. But basically, we are all thinking about resolutions. But when it is coming for implementation, all the authorities are against the SRS. For simple example, recent rule tax amendment, where it is saying all liabilities, whatever reduced or liability, will be considered as income and tax rate will be payable. Who will come for resolution concern? 100 crores rule not people will check it. How much claims have been reduced because of resolution? And previously, 2024, whatever liability is reduced, it will go to capital reserve. It will not affect the income. Now, because of new amendment in income tax, it says cash or kind received to the anyone need to be considered as income, need to be paid as tax. And many people receive the demands, and even if it is meant to CBDT, CBDT says to pay the tax. The resolution, we have to forget about resolution. We have to say then no individual asset wise sale only will be happen. This is a basic and very important concept, sir. And here is another very gray area. Demand also need to be payable. And another problem, sir. Here departments are coming to which client 14 years back, 15 years back to advice, sorry. 14 years back, 15 years back also they are giving client. Okay, somehow if we are paying the amount to the PF department, another question what is coming is they are not giving list of the employees to whom they will remit the amount. They are saying simply employee is responsible. 14 years back, clients, when company is went into insolvency, promoter is not able to traceable or not able to respond to NCLT orders also, the total amount is going to into dustbin. So because EF department is assessing based upon the present to basis. It is not based upon the actual facts. And PF says, so if you are not paid, I will file case against you. These type of statutory issues, unless we resolve, it will be big issues, sir. Income tax recent big issue, because of that, no resolution plans will come. Or 100 rupees asset ke liye, people will come for 10 rupees. This is my.
I hear you, sir.
Yes, sir.
Only thing, but I also have to say, coming from regulator side also,
Yes,
I cannot do anything on that other than to suggest to you that there is a select committee looking into the amendment bill that has been introduced in Parliament. So my suggestion to you would be that present these concerns to the select committee through maybe HIPAA or through some other.
so you also on behalf of us,
Yes. So we can go into that.
other people, unless see, I am very small in the system. I can't go to ask, but you are comparatively with me, you are much bigger. Your element have and so
society your jurisdiction is more comparatively.
No, I'm trying to be practical or kind of what actionable is that. See, so, but I think right now would be that, take for instance, to HIPAA, for instance, take his points, and then present it to the select committee. That would be more practical than us IPA looking into it because we will go through IBPI. IBPI will not present any this one because IBPI is part of the lawmaking process. You see, so it will get lost somewhere if you are giving me a suggestion to me. My purpose here was to hear on any practical membership issues or anything like that. Larger this one, I will not be able to solve it other than hear you. Like I said, I hear you.
So anyone who has a question, let it be to the IPA and IPA.
And obvious, not
For IPA, whatever concerns you have.
Sir, as a but the IBC pillars like NCLT or ABPA. So here this system, our IPA is supporting to the IP professionals because in most of the cases we can see that COC they are playing their role, corporate they are playing their role. Okay, when it comes to the IP, just we are watching the watchdog. Okay, so now we are not able to do anything. But at the end of the day, if anybody goes and gives the report anything about against the IP, immediately IPA and IPA immediately is coming and catching the persons. Okay, so how the IPA is protecting the IP professionals? See, we are the members of your organization. Most of the cases we have seen that so many disciplinary cases are coming. See, as an IP, when we are acting, we are responsible for the NCLT. We are responsible for the IBPA. We are responsible for corporate data, COC. At the end of the day, again, it is coming IBPA and IPA as a give the report to this complaints given by somebody else. Okay. Any report it comes immediately. These two areas we are getting the responses. When we are giving the complaint, I given the complaint 5 years back to the IBPA against the kind of issue I am facing. So till today, nobody is given the response. I given to 5 people, 5 levels, 5 emails I given. Single email I have not received the responses. Okay, if somebody is giving the again anything against the IP, immediately next week you will get the email about this one, why this one is happening. Okay, same time we will get from the IPA also. See, we are the members of the IPA. How you are giving the support to the IPs?
I will put it this way. in as much as that your question is rather demand is general, I also have to respond to you in general terms. Right? So one is there is a mandate for IPA to monitor the IPs. And the second mandate is facilitate professional development and development of profession. So IPS mandate is that. Now, protection of IPs, you say. I would say this grievance mechanism, grievance management mechanism, grievance handling mechanism, and disciplinary mechanism is the way IPA takes care of the interests of the IPs. See, using the grievances, the complaints that come from public, and anybody know that. They go through an elaborate mechanism from government, goes to PM's office or wherever goes through IPA, and IPA in turn passes it out to us, where IPA decides that you can handle it. Some of them they handle. They handle more complaints than the IPA. So that we have a very, the mechanism. So that is the way IPA takes care of the professional protection of IPs in their practice, keeping it within its jurisdiction, if I may. Just to mention, I just mentioned one more point in this because I cannot really go beyond that. That will not be of any use. So IPS handle grievances and any disciplinary mechanism in the classes required based on these 2 points. Whether the concerned IP has been not compliant with the code, the regulations, the rules. Whether the concerned member IP has been not compliant with the code of conduct. This is the mandate. We are not a law-making body. We are not a law enforcement authority. We are not an investigating authority. We do not have inspection. Our inspection is also purely based on the assignments. So, in as much as that, our protection role is in that time. Beyond that, yes, I mean, you may have some issue with IPA or IPBA that has not been addressed. You give me something specific, I will try to see if I can check it out, or rather than try to come back.
That is CPLs. See, most of the time, IPS, they conduct the online sessions. See, IPNet, they're conducting every week with very highly good speakers and they're giving free of cost. When it comes to the IPS, they are charging each session for our 250-300 rupees for online session. So members, most of the IPs, they don't have the assignments, but still they need to maintain the CP hours to keep the AFE. So it is costly expensive, and at the same time, sometimes it is not worth the session, but because of the CPA people, they are showing the interest. So that is the way also you need to consider something, because of most of the sessions are online. See, other CA institute, ICSI institute, they are charging per hour, 1 hour for physical sessions they are collecting. But when it comes to the IPS, so most of the sessions they are charging 250 rupees, 300 rupees per hour. So see, this profession, so already many of the IPs are struggling to get the works. They need to pay the annual maintenance and CP hours to keep all these things. It is coming expensive for most of the people. So I request you to look into that.
That's zero work.
Sorry?
That's zero work.
That's what. See.
I will let you in on a secret that I don't share much. I should not actually. You see, IPA is not self-sufficient. It is not earning enough to pay for itself.
Even IBBA also not self-sufficient. They are charging 1% economic loans. Is it a cooperative society?
Yeah.
Yeah, what is the logic in that?
No, I mean, you're saying that IPA is not supposed to be self-sufficient? I mean,
No, IBBA charging 1% from the even a notional amount, even though it is on the accrual basis. So they have to borrow from a bank and pay that.
it's not true.
Now, we should pay at all. First of all,
I think this is, no, that was much.
we are not. This is a government body, statutory body, created by law.
Yes.
Why they should charge even the members?
let me not presume for myself the role of speaking for this. No way that I can do. So,
No, it is economic. No, it is economic. To be honest, sir, it is economic one thing, sir. No, I know that because IPS are not self-sufficient. They are looking for raising some funds to.
No, I'm not saying that ABS are looking for raising funds.
No, no,
Don't get me
I'm
wrong.
not saying
Don't
that.
get me wrong. What I'm trying to say is, as on a sustainable basis, IPA has to be paying for itself. Do you agree? Anyone has to be paying for itself. IPA also has to be paying for itself.
No, I have
Right.
grievance with IBPA.
Like government IPA can only take your, there is no point. You said I cannot respond to you on behalf of IPA. So,
Sir, IPA, only IPA.
yeah.
So IPAs are there in between IPs and IBPA and acting as an agent between these two stakeholders, IBPA and IPs. So when we look at the other system, the SEBI, and SEBI is there, and under that different stakeholders like stockbroker, merchant banking, trade transfer register, then the stakeholders cannot communicate directly to the SEBI. So they have to communicate to the merchant banker or stockbroker or share transfer registrar. So these stakeholders will be responsible to the SEBI. Sometimes IBA will communicate to me, sometimes IPA communicate to me. So two way I have to communicate.
I understand. That part I can understand. So I can say one thing.
Even small CTA, they are not uploading within 3 days. They will not. What is they are doing anything wrong? But they are doing. They are mandating for the 1 year. 1 year means CS, we have 10 years experience. Whether we need to concentrate on the corporate data, whether we need to upload within 3 days. What is the more pressure on the IPs and no production from the IP player. Just looting the money on side and paying 1% from the account, 0.25%. Whether whether I get the salary or not.
No, I
Only, thank you. One last question.
There are problems with the CPA.
No, I just make a point. I understand. CPR's credit has been an issue. People have told me. While I can take feedback from you on behalf of our IPA, I cannot resolve anything or give you a response unless it is meant for our IPA. You will appreciate that, right? So, if anyone has any issues, any delays faced in CPR's credit, because you are a member of the IPF ICMAI, or because you have not got a credit for having attended a program conducted by IPF ICMAI, please give me the details. If there is an issue, we will take it with other IPS if required, or obviously if it is the question of our IPS, definitely will. Because you can appreciate that we can only write to the other IPA, right? I cannot say, yeah, ho jayega, kal ho jayega. I was about to say earlier that I get a sense of how politicians feel when they come up in public speaking and get people shout, looting and things like that. But again, at the same time, I cannot also go and promise you something that I cannot do. Right? Yeah.
Sir,
I think I've taken a lot of time.
Yes, sir.
last question. It's not a question, sir. There are problems with the AFA, CPE, and maybe inter-IPA. If I do CPE from you, it may be difficult for me to get approval from the other IPS also. There will be ironed out in course.
There's a very good process for that. Let's streamline process for that. And actually, the thing is, for some reason or the other, I'll not go into the reasons. There is all three IPS have got software ready, patch ready to have an automated direct credit without having to go through and get an authority and all this.
Not happening.
2 years, sir. Not 1 year. It's 2 years.
But it is not implemented.
It is not. I can tell you, we have spent money to get a software patch done. It was given upgrade because of some change.
Please, no cross talking, please.
Sir, one thing I have to appreciate your IBA, I don't know whether my wife or the children say good morning to me in the morning or not. When I open the mailbox, there will be good morning and so many programs. Which are you are empowering the professionals, sir. For that, it has become very tough.
That's why, please don't say we are rooting.
You are empowering, sir.
I'm also. I'm also.
One thing.
Thank you, everyone.
And just I just wanted to use this opportunity to inform you all. Many of you would be aware that, on an annual basis every year, we organize a residential retreat for IPs and all stakeholders of IBC ecosystem. There have been 2 so far. The third one is happening again, like earlier times, in the first or second week of January. This is likely to be in, because it's not yet gone to the board, but it's going to be a new place, likely to be in the east or northeast. So I would like you to use this opportunity. It will be a good event. Mr. Matija gave a very nice presentation in the last event that happened in Alapi in Kerala. It was much appreciated. I think he spoke about what you can look forward to in IBC 5 years next. That was in the beginning of 25. I look forward to see you, sir, in the next one also, next edition also. So, Mr. Matija will be there. So, I think it's a good opportunity. I welcome you all. I think this one will come shortly to you. Shortly, it's maybe about 15 days to within a month. There is enough time. Use opportunity. Let us meet in this other place. And it is a family event. It is for couples and if there's a child or something like that.
Thank you, sir. Thank you so much, sir. One minute, just leave. May I request Gopal Krishna sir to please come and present a token of our appreciation to Narasimha Prasad sir, please. Thank you, sir. Thank you so much. And sorry, sir, once you open the floor for grievances to be addressed, it will be like this. It's like a zero honor viewers and we utilize it. Thank you, everyone. Quickly join us for lunch and come back maybe within half an hour. Half an hour, please. Let's not miss Ashish Makhija sir's presentation and discussions here. So I request all of you to please come back sooner. Also, one more request. Kindly sign the attendance sheet, otherwise your CP hours will not be credited. Please be mindful of that one. Yeah, this is very important. Yeah, the most awaited session is about to start now. May I request Mr. Ashish Makhija sir to please come on the dais. Mr. Mallikarjun, President of VIVA, kindly accompany me to the dais. I request Ms. Kalpana to please come and present the sampling to Ashish Makhija sir, please. I request all the MC members of VIPA to join us to felicitate sir with a shawl, please. Gauss. Video, sir? Okay. How many of us are present here? We can do that. Sorry, sir. Yeah, now may I request our MC member, Mr. Murthy sir, to please come and introduce Ashish Pakija sir.
Everybody? So, everybody works with Makina sir, but it is customary to give a brief introduction about him. One way it is easy, one way it is difficult. Makina sir is a legal practitioner and academician specializing in insolvency and corporate law, corporate governance and forensic audit. He has established as a leading attorney in his field of law. He served for 6 years as a standing counsel for the official liquidator at the Ministry of Corporate Affairs, attached to the Honorable High Court of Delhi. He represents clients in insolvency, bankruptcy, corporate law, and arbitration matters. He holds a doctorate of judicial science, that is PhD in law, from Amro Law College, Atlanta. A chartered accountant, cost and management accountant. He earned 2 LLM degrees, one from USA and one from India, and he is also a registered insolvency professional. His expertise extends to training and educating. He is a World Bank trained corporate trainer. 14 books to his credit, and the list goes on, and it keeps on increasing. He served as an independent director on many boards of prominent companies. Beyond professional endeavors, he is also a golfer. A multifaceted experience, academic brilliance, and contribution to all the professional bodies he holds or he is a member of. A man and idea behind, of course, the implementation of IPNet, a national network where weekly seminars are held, conducted in more than where in every session we have at least a participation in presence of 350 plus members attending to all the programs of the IPNet. So a topic of much relevance is sharing wisdom on this. Thank you, sir.
First of all, very good afternoon to each one of you. It was always a delight to be amongst insolvency professionals, particularly in Hyderabad. I must share a small story with you. Hyderabad used to be my second home. I used to travel to Hyderabad at least once in 15 days. That was a long time back. So one of the gentlemen, like one of the chartered accountants, told me, he said, "Sir, why don't you buy a house here?" It has been always a delight, but of course, with COVID, then the things took a back seat, we doing virtually. I think that's also one of the blessings in disguise we are having. We can interact, we can see each other pan India. And the best thing is the PREC programs and other programs which have been conducted by IPAs, IBPIs, and of course IPNet. I think it's pan India. So this is what, and all of us have come together. And when he spoke about the IPNet was an idea which was floated almost a year ago, exactly on 7th September 2024. We started with IPNet. Today, we have completed, not today, maybe last week we completed 1 year, and I must share with you, we did not miss even a weekly seminar. We did 52 webinars week after week, and thanks to not only to me, it's a wonderful team. We have divided IPNet into 5 zones, and of course, South Zone is headed by Swasti ma'am. She's been doing a wonderful job, wonderful speakers, and we have tried to create many of the speakers out. So my humble request to all of you, if you wish that you would like to be a speaker, get in touch with me, get in touch with her, we will give you an opportunity. That's the way we have been doing it. So friends, today I think it's a wonderful program. I must thank, first of all, ICMA, IPA, Mr. Prasad is there, and of course, Kiva. They have taken a fantastic lead. They are doing wonderful job, Mr. Mallikarjun, Swasti ma'am, understanding and many others. Maybe I cannot be knowing who are people behind it, because a lot of people are there who work behind the show. I think I must, first of all, congratulate them for having such wonderful programs and with the very relevant topics which are meant for each and every one. And of course, we must thank FTCCI also, because they are also supporting us, and with IPNet also pitching in. So friends, now let us understand one very important. I think I have a time till 5 p.m. I believe.
Yes.
4 p.m.
4:15.
4:15. Okay. That's very important to ask. I'm a member of a Rotary Club. I think some of you might be members of Rotary Clubs. So our meetings, the weekly meetings, they start in time and they end in time. So our club meeting used to start at 6 p.m. and end at 7. So from 6 to 6:30, one of the presidents used to make announcements, a lot of announcements. Pulse polio, blood donation, and whatever the things our Rotary is doing. And from 6 to 6:30, we used to meet over a cup of tea, so like fellowship. And then from then 6:30, the meeting starts sharp. And the president used to take 10 minutes to make announcements. So one day he had a lot of announcements to make, and he continued up to 6:45. But last 20 minutes, one of the speakers was used to be called. When the speaker rose, he got typically only 10 minutes to speak. So he rose up and looked at our president. He said, "Sir, how long can I speak?" Our president very coolly replied. He said, "Sir, you can speak as long as you want, but our members will leave at 7. It's important to ask for the time. Otherwise, I'll be keeping on speaking and I don't know. Okay. So I think, friends, this is very important. In fact, during lunchtime, it was a wonderful lunch with the delicacies and all. And I remember there was a pan which was kept there. Right? Of course, I didn't touch the pan. I remember you see, Don picture and the song Khai Ke Pan. यहाँ पे लगा Khai Ke Pan है. But anyway, Pan India. Pan India. So now, friends, let us talk about IBC and also what are the changes we are expecting. The changes which we are expecting. Well, there have been a lot of things. If you look at IBC Bill 2025, there are almost around 65 clauses. Lot of changes. And one of the important chapters which is being added is relating to creditor-initiated insolvency resolution process. We always knew CIRP. Now we have to add one more I, CIIR. So now we are bringing it down. The government is trying to bring in a new process. How it is different from PPIRP, whether it will work or not, I think there are a lot of questions which need to be answered and a lot of things which need to be improved. I looked at the law with a microscope and I found that let us make it more practical if it has to be successful. So let's look at those provisions, friends. This is very, very important that we must know and we must share our thoughts also. So what I want is, while I'm explaining those things, I like to make it more interactive. Let's have the solutions also, suggestions also, and I request Anupam and Swasingam also to please note it down so that we can at least make a list and we can send a representation to the Parliamentary Standing Committee or Select Committee, whichever has been appointed, or to the Ministry of Corporate Affairs. I think we must do that. Maybe we can do it jointly from IPNet and also from the person. We do that. Friends, number one, what is the need for creditor-initiated insolvency resolution process? What is Section 7? Is it creditor-initiated or debtor-initiated? Creditor-initiated. So what was the need for bringing out a new process and Chapter 4A and a complete chapter which is there? It's not a single section, friends. It is 12 sections which they are, 11 sections typically they are trying to bring in into the law. So what they are saying is that a creditor, let's have a small overview of the proposed provisions first, and then we will go into the details and we'll try to see what is. So the key features are, let us look at this, that number one, only notified financial creditors can initiate. So number one, only financial creditors have been entitled to initiate this. not the corporate debtor, not the operational. So this is the CIIRP is actually financial, it should be FCIIRP, right? Financial Creditor Initiated Insolvency Resolution Process. A single financial creditor cannot do it. That financial creditor requires 51% approval of all the financial creditors. Now, assuming that financial creditor holds more than 51%, then I'm presuming he or she or they can start on their own because then their approval will be there. And the process will start from the publication of the announcement and also from the appointment of the resolution professional. So straight away, my dear friends, in this case, there is no question of IRP. The person will be appointed straight away as an RP and he will be making a public announcement. Who's going to appoint? That financial creditor. FC is going to be appointing that. So now you know.
51% also is a notified financial creditor or all the
Notified financial creditor. I'll come to that. I'm just showing you overview. We'll go into the minute details also. So now you know. You have to be good books of financial creditor. Right? So try to do that. So make good friends with the bankers. That is what is very important. In CIRP, the management is taken over by IRP and then later on by RP. In CIRP, debtor remains continued. RP is there to supervise. RP is there to monitor. RP can override even the non-compliant board actions. He will attend all board meetings and he has got veto power. He's got like Brahmastra. The board of directors, while under CIRP, pass a board resolution, RP can say, sorry, you will not pass this. Or this will not be done. So he has got like a veto power in this case. And the timeline has been shortened 150 days. Isn't it? So from these 330 days, now we are back to 150 days. And of course, they can say extendable only by 45 days and it will be extended only once. Law is not clear about exclusions, right? We will talk about that in a little while. I'm just showing you the features. This CIRP can also be converted into CIRP under some situations. No plan comes, no plan is approved, non-cooperation, or the creditors say we want to convert CIRP into CIRP. So this is just like a baby step. The final step could be CIRP later on, we don't know. So that is important. And the oversight is that assuming creditors together 51%, notified financial creditors, supposing they start, can the corporate debtor object? The answer is yes. So I am slightly confused by these provisions. So I'll take you to those minor details. I believe CIRP will be successful only if the financial creditors and the debtor cooperate. Now, if you are now giving a right to object, then again we are going into litigation. We are going into appeals. Before NCLAT, we are going into appeals before Supreme Court. How will you achieve 150 days? The target of 150 days. We will look at those details in a little while. So these are very important aspects, friends. So let us look at a glance. As I mentioned to you, there are many sections. So let us remember those sections, very easy to remember. First is 58A. A stands for applicable. Just remember with that, right? That formula is very important. Which debtors are covered and what are excluded? Now it will set the stage. Not all financial creditors. They cannot do it. The government will notify what kind of creditors are required to initiate. In fact, the word used is not even financial creditors word. You know what is the word which is used in law? Financial institutions. They have used the word financial institutions. That only they will be entitled to initiate or start the whole process. So this is very important that financial institution, of course, we know that financial institutions, the meaning of that is also given in, the definition is given in IBC provision, which are 58B is beginning. So beginning means beginning the process. That means how will you begin the process? You will need certain steps for the financial creditors to start. Some approvals are required. The debtors will be informed. appointment of the RP will take place. So these are the steps which are given in section 58. So please, you can link it with beginning the process. 58C, C means challenge. Now the debtor can challenge it before the court. So challenge is also possible, and under certain circumstances, they can challenge it before the adjudicator. And the time period for challenge given to them is 30 days. And 30 days further is given time to the adjudicating authority to decide on that project. 60 days. Now, in the meantime, CIR is going on. Objection filed 30 days plus 30 days, 60 days. Out of 150 days, 60 days are gone. And we are taking an ideal situation that the things will be decided in 60 days. So what will happen to the CIRP? Because by that time, his objection is pending, you expect any debtor to cooperate. He'll say, oh, my objection is pending, please wait for it. And the first application we will file before the adjudicating authorities, my lords, please grant us stay, so that they cannot begin. So ultimately, how far this is going to be successful, I think we really need to look into a lot of details. So that is C stands for challenge. That is the third section which is there. So D stands for duration. 58D talks about the time limit, 150 days plus one extension of 45 days. Only one extension. They said you cannot give beyond the 45 days. So if the plan doesn't come within 195 days, the company will go to CIR process. Doesn't end there. CIRP starts. From what stage? Well, that of course we are going to discuss. 58E talks about the executive role of the RP. So RP, what are his duties, what are his powers, how he's going to monitor, how he's going to supervise. They are given in 58E. So remember, E with executive powers of role of the RP. And 58F, naturally, debtor is in control, promoters are in control, so naturally they must have some duties or functions. So F is basically the functions of the management. This talking about what they need to do. They need to keep it as a going concern. They need to manage. IP will supervise, and he can also veto resolution. So veto power is there. Please remember that. We're going to discuss about this in a little while. I'm just showing you very broadly right now. 58G. G means guard, like a security guard who is standing outside your society premises, isn't it? Moratorium is like a security guard, isn't it? So nobody can interfere in the CIRP while the CIRP is going on. So G stands for moratorium, and friends, remember this, moratorium in CIRP is not automatic. Like in CIRP section 14, what does it say? On the insolvency commencement date, the adjudicating authority shall prohibit all of the following A, B, C, D. It is mandatory. But in this case, it is not mandatory. It is not automatic. If the RP feels that a moratorium is required, then we will move an application to the adjudicator. So this is also very important. And 58I. So 58H. H stands for handover. Handover means under certain circumstances, no plans come, or there is a non-cooperation, then the process gets converted. So the process of CIRP is handed over to CIRP. So handover is changing of the hands from CIRP to CIR process. And I stands for kind of withdrawal. So withdrawal is like interruption. So we are interrupting the process and we are saying we are taking back the entire CIRP. So public announcement can be withdrawn and with 90% COC. Just like in 12A, there is typically 90% approval of the COC, where you can withdraw the case. Here also, withdrawal is possible, provided 90% of the COC approves it, but it requires adjudicating. So it is not this thing. So that is in some quarters, this question has been raised. If financial creditors who are notified can start on their own, why can't they withdraw on their own? Why do you have to go to adjudicating authority for withdrawal? We'll discuss about that. And 58J is like if the plan is to be approved. So J You can link it with judicial approval of the plan, right? J stands for judicial approval. So COC approved plan will be submitted to the adjudicating authority for approval. Section 31 will apply. Mutatis mutandis. So that section will apply as it is. And 58K. K is like they are talking about the key linkages. What are, because they have not made it as a very independent process, they are borrowing some sections from PPIRP, they are borrowing some sections from CIRP also. So a lot of sections from CIRP will be applicable, like duties of the RP, section 18, section 25. So all those sections, section 28, 21, constitution of the COC, meetings of the COC, section 24. So all these sections will continue. In fact, 29A, 30, 31, all these sections of CIRP will also be equally applicable to CIRP. This is that section. So it's saying, it gives you the list of sections, what will apply to CIRP. So this is what I try to do your ABCD. So this is a chart whereby you can really remember that. So A is for applicability, B for beginning, C for challenge, D for duration, and so on and so forth. Very easy to remember if you do it this particular. Okay. I leave these slides with Swasni ma'am and Anu ma'am. They can be shared, right? These are for you, not for me. So if you wish to take a photo, that's all right. Otherwise, these will be shared with you. Now, this is something which a comparison has been made with the CIRP and CCIRP. You can look at it. In CIRP, financial creditor or operational creditor or debtor can start CIRP is only for notified financial creditors with 51% commitment. So number one, financial institutions which are notified. So central government has got the power to notify what kind of institutions will be. Maybe it could be banks, it could be ARCs, it could be NBFCs, we don't know right now. And management, RP takes over, debtor is out. In case of CIRP, as we know, here debtor stays in charge, stays in control, but RP supervises, just like in PPI. Right? And moratorium, automatic, as I told you in CIRP, but in this case, it has to be requested, not automatic. It doesn't start. This is also a big question. We're going to have a debate on this. Timeline, as I mentioned, where it is 330 days, here it is 150 plus 45 days. And objection, debtor or the corporate debtor, when an application is filed under section 7, 9, or 10, naturally they can come and object. Principles of natural justice. But in this particular case, they can object only after the process has been started, not before. Not before. So why are you not taking the consent of the debtor? If you are not taking, you are entering into litigation according to me. We will discuss on that. And of course, the conversion, in fact, the CIRP, if it is unsuccessful, liquidation starts as we know. But in this case, if CIRP is unsuccessful, CIRP will start. And then, of course, so 3 processes instead of 2. So this is one of the important aspects which are there. So let's now understand the this thing. Let's go a little deeper on 58A, and then we will also have discussions on these particular sections. So it introduces the creditor initiated resolution process. As we know, it will, one more thing, it may not apply to all corporate debtors also. The corporate debtors with certain kind of assets, certain kinds of income, or both below such level. So government may say you should not have assets more than 10 crores or 50 crores or 500 crores. We don't know. The word used is below that level. So that means the large industries will be typically out of CII. It could be medium, it could be little more than the medium, but less than the large. We don't know what will be the asset level, what will be the income level, and they say it should be below such level. So both levels will be notified by the city. And then, of course, they are also saying corporate debtors with such class of creditors, maybe home buyers, we don't know. So maybe home buyers cases may be eligible for CIIR. I think for them, I believe this could be a more successful. Because we want the promoters to remain in charge while a real estate case is going on, isn't it? An RP who comes into a real estate project, he doesn't have funds, he doesn't have the confidence of the home buyers, and he is expected to start the construction. Please tell me how many real estate projects, if somebody is doing it, how many construction projects have actually commenced during CIR, while the CIRP was going. This is very important because you don't have the funds, you don't have the approvals, even the licenses and other things are also all cancelled. So therefore, it is very pertinent because we have seen another process. I think my friends are aware. Long time back, reverse CIRP concept was also brought in. What was reverse CIRP? I think most of you must be aware. In a reverse CIRP, NCLAD, and NCLAD of course was very innovative in that particular case, and Supreme Court ultimately in Arun Kumar Jagatranka case also said NCLAD should not be known. Right? I think there were some strictures which were passed against the NCLAD in a very indirect manner, of course not in a direct manner. They said NCLTs and NCLAD should not be innovative and they should not go beyond the IBC. But they did that, right? Reverse CIRP. What is reverse CIRP? Reverse CIRP is that CIRP has started, RP is appointed, naturally RP has to be appointed. He works in close coordination with the promoters. And the project is continued. And once the project is complete, then the company is handed over back to the promoters. That is the closure of the CIR. It is known as reverse CIR. This was a new concept which was brought in. It was not thought of. It was never there, but this has happened in 1 or 2 cases. So based on assets, based on income and the debt class, what kind of a class could be their class of creditors? And of course, this government has also retained a power, such other category of corporate. So they can add on to that list over a period of time. So this is one of the important things which are there. But there are certain restrictions. If a company is already going into CIRP, can it start CIRP? Answer is no. If the company is already under liquidation, can it go back and say, I want to start CIRP? The answer is no. If you are already undergoing the process, it can't happen. And if you have already completed CIRP in last 3 years, you cannot start CIRP. That is also another one of the conditions. But here, I have got few, important statements to make, and let's debate on that also. An application for CIRP is pending before adjudicating authority under Section 7. Maybe one, maybe more than one. Even under 9 if it is pending. And in the meantime, CIRP starts. There is no approval of adjudicating authorities required. Only 100% approval of the notified financial institution is required. Supposing they come together and they say, we will start CIR. What will be the fate of such applicants? And assuming they are in an advanced stage, supposing the orders have been reserved by adjudicating authority, then what happens? The law says that the moment CIRP starts, adjudicating authority will not decide any application of CIRP. Pass any order.
Automatic moratorium is not there, then indirectly restricting the adjudicating authority. Besides those aspects.
Well, they are wanting that, look, this is, according to me, that is what I got a feeling when I read those provisions number of times, that it has to be a cooperative exercise. It has to be a collaborative exercise. It can't be that you are fighting with the promoters and then you give them a charge that, oh, you remain in this particular case and then we'll continue with this process. That cannot happen. According to me, it has to be a collaborative exercise. So compliant promoters typically would come forward and only then this would be successful. So this is one of the importance of things. Pending applications will not be decided. And now, one more thing.
But in that case, CIRP has started. Debtor would anyway initiate another application objecting for that because has got the right to object.
So CIRP once starts, then he can file an objection because CIRP meter starts.
It amounts to 2 cases pending.
One thing I would like to mention before we go into this discussion. What is the insolvency commencement date in CIIR? In CIRP, it is the date of the order of the adjudicating authority. We are all clear. That is ICD. In this case, ICD is the publication of the public announcement. The day it is published, it is CIRP ICD. So that is typically that is that. Now, having done that, so that means CIRP has started. So all those pending applications will not be taken care of. Once it is started, a public announcement is published. Within 30 days, this debtor can file an objection. The debtor can file an objection. So it is not before he files objections after the commencement date. That is a problematic case. Yes, sir, I agree with you. This is going to be a very, very problematic. Now, these are the things which are there. I think we have already seen this 58B. Now, B is like beginning the process. How the process will begin? A financial creditor belonging to such class of financial institutions. We don't know what class. The government will decide. As notified by the central government, that is what they said. Provided the company has committed a default, now they may initiate CIIRP by appointing an RP. So they are going to select an RP and they are going to appoint the RP. Now, before doing that, what are the few steps which they have to take? Number one, they have to take approval of 51% of such class of financial institutions. Now, here comes 2-3 problems, which I can anticipate. Maybe we can also interact and we can debate on this. Supposing I am SBI, I want to start, I am holding 40%. Do I know who are the other financial institutions? Maybe from the balance sheet I can get to know of it, but at the end of the day, I need information from the company itself. Company has to inform me, right, who are the other financial institutions. Now, number two, how will you decide 51%? Bank of Baroda will say, my claim is 500 crores. SBI will say, no, your claim is 300 crores. How will you calculate 51%? Financial institutions will fight on the percentage. We have seen that. Some financial institutions, the claims are admitted, they say RP has admitted at a lower value. Our claim is higher because they will add interest, penal interest, and they add all an option of expenses, isn't it? We have seen that. As RPs, we have sometimes reduced their claims also. They said, no, you have calculated it wrongly. So is it a self-calculation? Who is going to calculate? Nothing is clear.
This is consortium percentage.
So consortium is all right, but I'm only saying what is the outstanding in the company's account. It is a day-to-day balance which is there. Unless the corporate data shares how another institute who is sitting in their offices will come to them. It may be consortium, it may not be consortium. So let's understand. Yes. Information utility does not contain the daily balance, outstanding balance. It only contains that a loan has been given or if a default is coming. It only contains that kind of a financial info. I don't think it contains day-to-day balance. So day-to-day
short update only at the time of taking.
Only at the time of loan or at the time of default. At that time of the
Even default also, they themselves decide it is a default.
Who decides?
Financial.
Naturally, no, but as far as the default is concerned, once they inform, a letter is sent to the corporate. It's not voluntary, it's not that unilateral. Naturally, an intimation goes whether you agree or you disagree or something like that. So naturally, the CD can object. That's not the point. But here, they have to take first the approval of the financial creditors of the CD. So I need to have a list. So I think the problem starts from here. Number one, who are the other financial institutions? I may or I may not know. Number two, what are their balances outstanding in the company? How will I arrive at 51%? Because here the company is not involved. The financial institutions sitting in their offices or conference rooms are deciding whether we should start. Of course, they can get a data from corporate data. Naturally, they can ask. There is no quarrel, but I don't know. So this is one of the important things.
Suppose I am being an SBI, I assume that I have 51%. I have initiated the action. Later on, some institution has come, no, you do not have 51%. But CIRP has been commenced.
So that is the problem. So this is going to be, that's why I said it will give it point to more litigation. Because number one, there is no credible information of outstanding balance today anywhere in public domain. So if it is not available, how will I decide 51% of my income? So it's a self-calculation.
Maybe some regulation may come.
So regulations may come, but at the end of the day, so what happens? It's like SBI will say, my today's claim as per my ledger account is to 321 crores. And how it has been calculated, whether it is correct or not, whether it is also reflected in CP's books or not, we don't know. That is the dispute which is going to occur between two. In fact, many financial institutions are fighting. I think if you are aware, PNB has filed various applications against Edelweiss that their claims is exaggerated, typically against ARCs. Their claims are very, very exaggerated. You have also seen that probably. Okay, so this is one. Now, what is the next step we have to do? So first step is they will by 51% decide that we want to start CII. This is the first step.
Are you obligated to communicate to the other banks to get that receipt?
Actually, they will have to do it because how will you get gather 51%?
That when the section is not clear about the process.
Correct.
So then in that case, within 30 days, they can initiate another proceeding, surface proceeding, some other proceeding. That's a part of
If you see, it's in any case not part. At the time the company is a working company, it is not under CIRP, nobody can stop to invoke surfacing. But the moment CIRP starts, there is no moratorium right now, automatic. But if the moratorium comes, then surfacing will also stop. So now this is one part where we have to see how we calculate 51% in value of the debt. That is a very critical question which should be decided. Number two, the moment they decide, so assuming they have passed 50, one more thing. Here there is a question of communicating with all FIs, financial institutions, and take 51%. Now, the other thing which is not clear is supposing State Bank of India has got 60% in their pocket. Do they still need to communicate with others? Or they can say, I'm 60%, I'm starting it, sorry, I don't care about you. How is it going? Who is going to provide that list? So it simply says that I obtain the approval of the financial creditors or belonging to the class who represent not less than 51%. So what is the word? To take approval. Supposing two people, say SBI and Bank of Baroda, in their conference rooms, they decide, let us start because both of us are more than 51%. Forget about the 49%. We don't care. They say you have to take approval of 51% only. So how do I read it? Should it be at the meeting of the financial institution, or two people can join hands, or a single person holding more than 51% can decide on its own? This is not. I think probably rules and regulations may come because it says in such manner as may be specified. So specified probably the regulations.
Vendor consortium meetings might be a place where they will decide and say.
So vendor consortium is typically consisting of the banks and the financial institutions. It does not include NBFCs. So if NBFCs are also notified financial institutions tomorrow, which is possible, go to the definition of financial institution. What does it say? Scheduled banks. Financial institutions as per section 45I of the Reserve Bank of India Act. Public financial institutions as per Companies Act, or such other institution has been notified by the central government, which has not been done. So it is the entire gamut. So how do you, so consortium probably is 3, 4, 5 bankers are there. But what happens to the other financial creditors? Suppose they are also notified, like NBFCs, ARCs. We don't know whether ARCs will also be part of consortium or not. So I think there is some loop.
Generally, the lenders consortium, not the consortium of banks. Generally, we have lenders consortium going on there, and the discussion is also there.
Assuming sir, lenders consortium is also there. Is it there in every company? 5% companies, 10% companies, what happens to 90%?
It may not be applicable to consortium.
It may not be
Unless they decide the
limits.
Correct. That also. Now the second step. The second step is once they decide and pass a resolution or approval, and not a resolution. The word is not resolution. Approval of 51% of the financial institution. That is the end of the story. So two people can join and they say we have approved it more than 51%. We don't care about 49%. Then they will inform the corporate debtor that their intention to start CIIR. That is the second step which they are going to do, and then they are going to give them a period of 30 days to make a representation. Mr. CD, you want to say something? Give your representation. We will consider your representation. Third, after consideration of the representation, which is received, time period not mentioned now. 30 days is given to the CD to make representation. In how many days they have to consider the representation? Nothing is mentioned. Can they keep it pending for 3 months? We don't know. Nothing is mentioned. Maybe it may come into the rules. Then they say it shall obtain the approval of the financial creditors of the corporate debtor belonging to such class, the same class as notified under subsection 1, same class, who represent not less than 51% of creditors in value. Of course, it says within 30 days. So 30 days is mentioned here. Again, 30 days they will have to take approval. So second approval also goes to the financial institutions. The first approval to initiate, intention to initiate. Intention to initiate is communicated to CD. CD makes a representation. That representation is considered. And after the consideration, still if they wish to begin the process, they will have to get it approved with again 51% of the financial in value. So this is the whole amount of it, because there could be a dispute on the value of the debt, as I mentioned. And number two, how they will come to know what is the debt of the other institution if they are not in consortium. So that is one of the important aspects. If the CD does not respond within 30 days, they can take a call on their own. And if after the representation, they do not pass a resolution, it does not get approved, that means the CIRP doesn't get approved by the financial institution, they will have to go back to step number 1. It is not that it is the end of the matter. Well, period is over, 30 plus 30, 60 days, you have not taken a call, you have not approved it, go back to the first step now. Again, take approval of 51%, inform the CD, they may take representation, consider representation, and get it approved. I don't know what is this. This process can continue one after the other. There has to be an end to that problem. Once it is fails, it fails. So they should not be allowed to have repeated this kind of sections which are there. So this is very, very important, right? Now there is an explanation which has been added to section 58B. Now this is very important. I will read it for you. Just listen to me carefully and let us try to understand and make a sense out of it. It says, for the purposes of this section, it is hereby clarified that where the corporate debtor does not make a representation within the period given by the financial creditor under clause B, that is within 30 days, the financial creditor may, after the expiry of such period, proceed to appoint the resolution professional in accordance with the provision of subsection. So let us take two situations. CD is intimated, CD makes a representation to be considered, and second time approval is required for starting of the CIR fund, the extended is fund. CD is intimated, second situation. CD does not make a representation. Does it require second approval of the financial institution? Explanation says no. Now no approval. There no representation has come. So now the earlier decision of 51% will be valid, and they will straight away now appoint an RP who is going to make a public announcement. And from the date of the public announcement, CIRP shall commence. This is very, very important, my dear friends, right? So, and number two, financial institution who has initiated the process originally, they will get to appoint the RP. They may not consult anyone else. So if SBI is starting it, SBI will appoint, right? Now the second part, they may appoint an IP as the RP. So there is no interim resolution professional, straight away RP, if no discipline proceedings are pending against him. Naturally, of course, They will not come to know whether the disciplinary proceedings are pending. They will take an undertaking from the RP or IP to say that look whether anything is pending against you or not. So this is exactly what is being done in adjudicating authority policy. So now when the RP, when you are appointed, my dear friends, you will first make a public announcement that CIRP has been initiated, and then he will communicate. Now this is important. He's not taking approval. He will communicate by way of a report. He will create a report now, and he will report that to the adjudicating authority and to RP. He has to send his report to 2 places. And of course, his report to adjudicating authority will be in the form of IA only, right? As we all know. So this is the whole process which has been thought about there, right? And they say that during the process of CIIRP, supposing it is going on, no application shall be filed or admitted under section 7, 9 or 10. Not only decided, can't be filed also. Now, how an operational creditor will come to know?
Public announcement.
Public announcement, kitne padte hain? How many of them?
But is it not my rights have been curtailed, not this?
This is not to be changed.
Somebody has initiated, but my right has been.
Yeah, that's the point. If I am an operational creditor, now you are taking away my right to start the CIRP. Not even fine. It is fine. You will not admit you keep my application pending. I can understand. But it says no application shall be filed or admitted. So first, all OCs and all creditors should be aware of this one. Number one, that CIRP has been commenced. Maybe it will come in rules. The moment CIRP commences, RP will have to communicate, send a communication to all OCs and all that. Of course, that is fine because in any case, those responsibilities are there. Sorry,
Communicate to the registry of that jurisdiction. That would be enough.
registry means sir.
ROC.
No. See, that is all right, sir. But how many of the people go to that particular thing?
Actually, it's to initiate that. Yeah.
Right.
So they communicate to the registry when anybody makes an application and the paying.
But the contrary can happen. Suppose they financial data expresses the intention to the CD. Then CD might instigate another operational unit to initiate regular CIR. Regulation.
But the moment this CIRP starts, then that will have no meaning. That's all. That will have no meaning. So that is the whole process.
But the operation data can still it's not apart from
Yeah, naturally. See, the point is, let's understand. CIRP is an additional right given to some kinds of financial creditors. It's not given to everyone, right? So section 7 is still there, 9 is there, 10 is there. And financial creditors have additional remedy to go to DRT, to invoke SARFAESI, whatever they want to do. But the question is, the moment CIRP begins, moratorium comes into place, so everything comes under a stay, standstill. But at the end of the year, there is no automatic moratorium. So even SARFAESI action can continue. That is dangerous. That is dangerous. So I don't know why the automatic moratorium has been changed or tweaked to make an application to the NGT. Now that is something which is we can't really think of it because this is going to make it very, very unsuccessful from the day one. So, or probably their thinking would be, look, promoters are running the company, so they should continue to pay the credit just like they are paying everyone. But then, can they sell the property? Because in 14(1), sale of property is also barred. And if moratorium is not there, they will continue to sell properties also during CIR.
CIRP, the adjudicating authority is granting the moratorium while admitting the application.
Correct.
But in CIRP, adjudicating authority is not there. On their own, they are initiated.
Correct.
That's what they are not a automatic moratorium. They are not giving. They are asking, coming to adjudicating authority.
So please understand. Let's look at this. CIRP also says when the NCLT orders it, it shall pass the order.
Is there any choice with the adjudicating authority? So it becomes mandatory. So they could have brought in the mandatory provision. The moment it commences, automatic moratorium kicks in. I don't think. See, adjudicating authority, supposing it doesn't pass the order under 14 months, so will the moratorium not be there? Still, the moratorium has to be there, right? That is that. Now, one more aspect which is very, very important. The objection can be filed by the CD on the publication of the public announcement. They can't file it before. First, they have to make a representation to the financial institutions, which will be considered and probably it will be rejected. And then they will say, okay, publish the public announcement, RP does it. And CIRP starts. This is what the law says. Now, objection can be filed by the CD within 30 days of the public announcement publication. That is the date. Filing an objection is like a filing an appeal to the order, right? It's an objection only. Now, I have got a small dichotomy here. To file an objection, CD would require a board resolution. I think all of the company secretaries will understand without a board resolution, you can't proceed. Unless you have an omnibus resolution earlier passed, otherwise you need an authority who is going to challenge it, who is going to file it, who is the lawyer being appointed in this case. So they need to pass a board resolution. And RP will attend all board meetings and he gets a veto power under 58E subsection 2. So the board resolution says, we want to file an objection, RP says veto power. Then what happens?
No, there is a concept of interested matter will come. Being RP is interested, he may be FTCCI.
So RP may not be interested in this case, now, because at the end of the day,
The objection is purely on the process of CRP. Then definitely the interested party not that.
No,
Then
that
the
is
outside plays a role of related party and interested party.
right. So interested party will come in most of the things. Yeah. Like CRP cost to be paid, then even an RP will be there. So those kind of things are there. But according to me, as our friend is saying, this will not happen because this is a statutory right given to the debtors. So it can't be taken away on via veto power. So there is a slight dichotomy there, but at least the government can clarify and look at this. This is very, very important. Okay. And now the question of cooperation. This is very important. I have filed an objection. I can file within 30 days. 30 days time is given to the AA to decide on this. Well, this time period is very, very minimal. I don't think this will be compliant with. But let us assume an ideal situation, 60 days. You think the CD will cooperate during the 60 days? They will say, I filed an objection, please wait for it. Why should I do it? So what happens to 150 days then? Will this 60 days be excluded from 150 days? We don't. Nothing is clear. They have not typically mentioned on this particular case. Okay. Now, assuming objection has been filed, 2 objections can be taken. A, default has not occurred. Now, this is a very dangerous thing. Financial institution says default has occurred. CD says default has not occurred. But regardless of that, process has started. Now, CD goes to the adjudicating authority, says, my lords, default has not occurred. And 2, they have not followed the process which is later. 51% representation, 30 days, second approval, they have not done it properly. RP not appointed properly, there could be number of objections. But primarily 2, default has not occurred, process not followed, which is new. Now here comes the breakup now. It says adjudicating authority, if it feels that the default has not occurred, if it decides, actually they have to adjudicate this dispute, then they will declare CIRP void ab initio. They will say nothing doing, the process has not started, failed. Void ab initio from the very beginning. Number 2, if they say default has occurred, but the process which is laid down in 58.1, 58A, 58B, 1 and 2 has not been followed, then in that case, they will convert the CIRP into CIR. They are not going to give a second chance to the financial institution, follow the process. They say default has occurred, default is required, no more application. Your start of the process will be treated as a Section 7 application and we will now order CIR. We'll send the company to CIR. So 60 days gone, assuming ideal situation, 60 days gone, CIRP starts. So you could have started in Section 7 itself then. You want to start CIRP automatically here, right? So this is another proposal, another thing which has been mentioned here, right? So they will have to pass the order, and this order has to be passed typically within 30 days. So that is the 30-day period which has been given to them. So let's now move forward. Initiation, I think we have already covered. I don't know why it is. Yeah, okay. So timeline for completion. Let's go to timeline now. Timeline for completion is very simple, my dear friends. 150 days and 45 days. With of course 66% approval of the COC, you can extend the time. You can approach the adjudicating authority, and then it says the strict timelines are there. Only once the approval can be given, extension can be given, and if the resolution plan is not approved in time. Two situations: plan doesn't come, plan comes not approved. So in both the situations, now adjudicating authority will convert CIRP into CIR. So promoters have no respite. Once CIRP starts, either the plan is approved or the company goes into CIR. Now here is a problem. There are 3-4 situations which they have considered that under what situations CIRP will be converted into CIR. Number 1, the first one they say is no plan is received. Number 2, non-cooperation by the promoters or directors. Number 3, rejection of the plan. Number 4, decision of the COC to convert CIRP into CIRP. These are the only 4 situations which have been anticipated. Now here comes another problem, and let's discuss on that. Supposing everything has happened, claims have been invited, Form G was published, because that is also to be published, invitation of the resolution plans, everything will be done accordingly. And later on, plan comes, not approved, plan doesn't come, whatever the situation is. 150 days, or maybe 195 days. Let's take now 95 days. Now, after this particular 195 days, what happens? Company is sent into CIR.
Sir, is it not about the duplication of the process?
That's what we are discussing, sir. The one is duplication. Let's understand one more thing. From what stage the CIRP will start? You know what the law says? Law says adjudicating authority will decide from which state now the CIRP will start. It's on a case-to-case basis. They can say claims have been received. Sorry, don't invite claims again. Start from Form 5. That will be, according to me, will be more sensible. Starting from Form G, invite again the plans of the. So the stage of approval, stage of starting of the CIRP will be decided by the committee.
Fresh application.
No fresh application.
Order
It is a conversion of CIRP into CIRP. And the person who initiated, he will be treated as an applicant under Section 7.
But what makes difference, sir? Once plan has been received, suppose plan has been received, rejected, again calling for a plan, again they may be rejected. Same kind of plan, same kind of.
Typically speaking, 330 days which are given in CIRP, which we have seen in practice, how many days are there? 752 on an average. IBC report says, right? So now we are extending even 752 to 1000 days.
Again, same process we have followed.
Same RP continues, sir.
Another interesting thing. Same RP can be appointed as an IRP or an RP depending on what stage. So if it starts from the 0 stage, then you will be now degraded from RP to IRP. But if the adjudicating authority says it will start from Form G, so will continue to be an RP. Or adjudicating authority can appoint somebody else. That is also there. But typically it says RP will be appointed as IRP or RP. That is it. Depending upon what stage. Okay.
No fresh application,
No fresh application.
no fresh fee.
No fresh fee. So it is without fees. That is important. So you are adopting a route where you are avoiding 25,000 rupees to pay to adjudication. First, delay the process, give an advantage. So see, friends, let us also discuss on this, and then probably we'll break for tea. Is it right for tea now? Okay. So we'll break for tea for 10 minutes and then we'll come back. The point what I'm trying to convey is this: that the moment this CIRP starts, now, if it fails for whatever reason, it could fail. Now we are starting the whole process again. That is one of the objections to us, delaying the whole thing, and then litigation. Supposing somebody's plan is rejected, you will naturally file an objection. You will go to inquiry, you will go to Supreme Court. Supreme Court says, "Tab tak stay karo." Well, you will see, happy will not start. So you are actually giving rise to more litigation accordingly. Now we will have a debate after the tea, and whether this is better or I have some alternative, right? We will have a discussion on this. If that alternative is better, I'll give you certain examples, and then we'll like to discuss. We'll make note of those points, and then probably we can make a representation on those points, right? So if the tea is ready, we can break. We can just check up, or let me continue otherwise for some time.
Is it something like substitute to abstract?
It's a repack also.
It is a hybrid between CIRP and PPIR. Because CIRP promoters out, PPIRP promoters in. Right? So here, but there the debtor starts. Debtor approaches the creditor. There the creditor starts. So it is like a hybrid between the two. One has already failed. We have seen that. PPIRP has not been a success. For whatever reasons it was there. So now we are trying to build in another PPIRP, but we are not calling it as PPIRP, we are calling it as CIIR.
PPIRP continues, sir.
PPIRP. But that is only for MSME. This will be beyond MSMEs, but lower than the maybe some large investments. So that is the most big cover. So if it covers both MSMEs also, probably they will have two processes there. So you can choose between them, right? So this is the whole process which is right. So friends, I think let's have a break for 10 minutes, and then we'll come back and continue with the other provisions. A lot of interesting discussions are there. It is only a warm up right now. Great, thank you so much.
I request all the members to please settle down quickly. We are going to start the session again. I request all the members, once again reminding who have not signed your attendance sheet, kindly sign it once again, or maybe kindly sign it, and because without that we will not be able to give CPRs. And those of you who have not paid the fees, kindly make the payment also. Feedback form has been given to you, kindly fill that up with your name and give it back to us. Thank you.
Okay, friends, welcome back. So shall we start now?
Yes, sir.
Okay, let's restart. So we were talking about it is mandatory to convert the CIRP into CIR. And the person who initiated will be treated as an applicant, and the adjudicating authority has got the power to decide the stage from which the CIRP will be. And they will also appoint the RP as IRP or RP, depending upon the stage. Now, what happens to the CIRP cost? Very logical. CIRP cost will be treated as CIRP cost. Okay, if it is not paid. And now it says adjudicating authority shall declare a moratorium under section. Because of automatic moratorium, so they will have to really do with that. Okay. So and there is one more thing, because I told you 4 situations. Even the creditors at any stage can decide that we would like to convert CIRP into CIR. So they can also decide, right? So that is what our friend also said. They are avoiding 25,000 rupees fees also. So initiate CIRP, next day decide we want to convert it. But we have 25,000 also not to be paid to actually. Okay. So now one of the most important aspects is,
Sir, in converting CIRP to CIRP, is there any again going to adjudicate authority, gets the stamp, moratorium, everything?
yeah. Once the because you see, you will submit that no plan has come, or plan has come, they have rejected it, or creditors decide, or there is a non-cooperation report which is filed. 4 situations. Then they have to mandatorily convert CIRP into CIR. And this CIRP will be treated as an order under section 7. And including the moratorium, and these things have to be seen in that context only. Now, one of the important aspects which are there is, what will be the date of ICD when the CIRP starts? Conversion. CIRP was there, not successful, automatically gets converted into CIRP. What will be the date of, what will be the ICD, insolvency constitution?
Previous date only. Already CIRP comments.
Depends on the stage at which.
No, on the date when they convert, should that become ICD? Or the second is the earlier date of CIRP date, which should become the ICD.
Second one.
Converted.
Second one.
Conversion?
Half of the time, stage at which they are
Like BPARP.
going to be defined. So naturally, earlier than taxes.
Timelines.
Anyway, NCLT is always.
So, the initiation date will be, because now I tell you one more thing which is important. With this IBC bill 2025, I think you might have heard me when I took 2 sessions of 5 hours, marathon sessions which were there, going clause by clause. The relevance of insolvency commencement date is going down the water. It is a sunset clause. What the new bill proposes to do and change the entire exercise of IBC is, initiation date will be the most important. Now, what is the initiation date in CIRP? When I file an application. Supposing a second creditor files, that is the second initiation date. Third creditor files, supposing 3 applications are pending, there are 3 initiation dates. And ICD is typically treated when the adjudicating authority passes an order. It says, yes, we are starting the CIRP, and everything I must say is turned on ICD. This is sacrosanct. Claims are to be filed up to ICD. All avoidance application have to be seen. The relevant period is seen backwards to the ICD. I think ICD is the most important thing. 180 days are to be calculated from that date itself, isn't it? But now the whole game plan is being changed by IBC, and this is also affecting the CIRP. Initiation date will be the date for the purposes of avoidance application. For the purposes of avoidance application. And the CIRP initiation date will also be considered very important in the sense that from this period towards the other period when the CIRP actually starts. So the period of CIRP will be started from the initiation date and going up to the last date whenever it comes. So that is the huge change which is coming up, particularly in case of avoidance application, because we felt that, right? Assuming, let's take an example. 1st January 2022, an application filed. Admitted on 1st January 2024. 2 years it took, right? Sometimes it takes that much of time. You are appointed as an RP, you have to look at the avoidance transaction. You will look back in case of related party transactions 2 years prior to 1/1/2024. So between 2022 and 2024, nothing would happen because promoters were cautious. You will find material prior to 1/1/2022, but your range ends on that date. You can't go beyond that except for section 66, which are fraudulent transactions. For preferential transaction, for undervalued, for transaction defrauding creditors and extortionate, your time period starts from backwards to ICD. So the time consumed in admission takes care of the promoters. Promoters are happy to delay. Now, to cover that up, now they are saying that the initiation day, now the info as far as the avoidance transaction time period is to be seen, it will be seen prior to initiation date and not the ICD.
Yesterday I was meeting one bank, senior banker.
Yes,
What he was suggesting, the date of NPA should be the profession.
Even today, from the date of ICD, how many cases to file for the period? Any one output from budget to Mr. last year?
There have been 50, if you ask me, sir, there have been 50 cases.
Sir.
But now look at the next step. How many recoveries have been made?
That is the truth.
Order to pass kar diya 400 crore ka. But that person is absconding, you are not able to recover, that remains on paper only.
Ultimately, burden on the IBC.
As an IP is concerned, sir, there is no burden, you have to do this, you have to perform your duty. That is why I say, and this is, you must note it down, my dear friends, another provision which is being brought in IBC now, and they are changing section 45, I believe, yeah, or not 45, 49. 49 was that if there is an undervalued transaction and it is a fraudulent transaction, then of course, any creditor can file before the adjudicating authority, and if the creditor files, then it will be treated as a complaint to the IPDI. That RP missed it. That was only one section which was very important in that sense. But now, section 47. Now they are replacing the entire 47. They say any creditor, any member, or any stakeholder, if he feels that RP or liquidator has missed filing PUFE or fraudulent transactions, then he can file an application and this will be treated as a show cause notice to the IBC. So therefore, my dear friends, now on, please do not think that I am not going to file it. Whether it gets rejected at the adjudicating authority level, you don't care. You do your best, get a forensic audit, whatever evidence is there, please do not apply your mind whether this is a preferential or not. File it. File it.
The promoters are not providing any data.
I know.
And
that.
forensic audit report, it will show because of lack of information, we are not able to identify anything.
Report is in 10 pages, disclaimer is in 12 pages.
So I would say last and bankers will ask whether you comply or not. What we need to do, sir? We are also.
But sir, let's discuss, let's go backwards. Those who are bankers, they're experienced bankers who are already here. You know, when the account was operating, you had all the authority to conduct forensic audit. In fact, according to me, if you ask me, forensic auditor once in a year should be made mandatory even in companies act now. What is the problem? If I am doing clearly in a transparent manner, I have nothing to hide, or maybe you can have more than 500 crore level or whatever, some level can be there. But at the end of the day, sir, what the bankers were doing? They were the people who were sitting on the board. They were the people who were looking after the major transactions. They had access to all bank accounts of the company. They had access to all transactions. If they would have been more careful, why the company should slide into insolvency? I think if we start working on that systemic manner, I think the case is good, but that is not good for IBC. So let it remain as. Yes, sir.
All ASM,
Okay,
all 250 crore above there,
right,
the transaction is put through this auditor.
okay. Auditor, we have the concurrent auditor.
No, is.
Agency for special monitoring, then another IBM panel.
It means the bankers are aware what is happening.
IBA is apparently the auditors for this,
Right.
all 250 above.
But then, sir, my question is then why this happens then?
It started recently.
Actually, it started.
Yeah.
So let's hope it will make an impact. Okay. Now let us come down to the next, I think we have already covered up. For 58E, I think the duties and other things, let us look at, these are the important aspects which we must look at. They say RP will exercise the powers and perform the following functions, following powers and duties. Number one, first is calling for the claims. So naturally, in a public announcement, you will invite claims. Prepare the IM. So IM again is the responsibility of the RP naturally, but since the promoters are there, they need to cooperate. So you will get better cooperation. This is what we think about it. Should be better cooperation. Then he has to prepare a report. Of course, they say in such form as may be specified, so it will be going to be a long report. Whether the conduct of the CIRP is in accordance with the procedural requirement and the resolution plan which has been filed confirms to 29A and section 20. So same requirements of 29A eligibility, 30 subsection 2, that these are the mandatory contents of the resolution plan. The same provisions are also applied here. Similarly, section 18, not all duties, they are saying duties which are mentioned in clauses A to C are applicable in this case. In section 25, the RP's duties, clauses E to J. The previous clauses relating to interpretation of other things, claims and all that has been deleted from there. They say they will also apply to this particular process. And then he's drawing powers not only from 18, not only from 25, he's also drawing powers from PPIRP, section 54F. This is where the confusion starts. If you are creating a new chapter, why can't you make it as a standalone chapter then? Why have to go back to section 18? Why have to go back to section 25? You could have mentioned those powers and duties in one section and end of the story. You say you will also enjoy power under 54F, PPIRP. You will enjoy power under section 18, clauses A to E, not other clauses. I think it's all very confusing. They're making it very, very complex. This could have been avoided by this point. I've seen.
If 29A also applied here in
Yes.
CIRP, so being a promoter of the company, though I am in a control during the
I
CIRP,
will not be able to fight.
why should I cooperate?
That's
Because end of the day,
the moot point. That is the moot point. If it is, because we were discussing just now, that it is nothing but another form of OTS. OTS is that where the borrower and the lender sit down and agree on certain terms and conditions. That means the borrower remains in control. But here, since if the account is NPA, typically they are ineligible under 29AC, most of them, then they will not be able to find that time. Unless they are MSME.
Yeah.
If they are MSME, then of course benefit of section 240A will come to them. But if there is not MSME, then they are going to lose their company. And if they are going to lose their company, naturally now they are going to object to CIRP also. And a lot of litigation. And they will delay so that this is not successful, at least it is converted into CIRP so that they get more time. That is why I am saying it is not going to be successful. If you bring 29A here, that means I have to lose my company, but I still cooperate with you. Who's going to do that? Very rare, isn't it? Or, now the second part comes, or here the manipulation will start. You are seeing that? through ARCs, through another party, backdoor entry. So happening. All of us are suffering. I don't want to say at this public forum, but let me tell you in a very brief manner. I think our friend was talking about avoidance application, that the fate doesn't happen. I was requested by one of the RP argue in Chennai bench on an avoidance application. So I went there physically, argued 2 times for 3 hours. There was a cash shortage of 50 lakh. Small amount. 50 lakhs is not a small amount. Of course, in the gamut of the company of a 5,000 crore company, it may be a small amount, but it was not that large amount. Besides that, there were other transactions which were there, worth almost around 100 crores, which were avoidance transactions, which RP pointed out. He did a fantastic job. Forensic audit report will find complete evidence. And I argued the matter. And when I came back to Delhi, RP told me, he said, opposite counsel came to me. He said, sir, we have no case, your lawyer has demolished everything. These were his words. Order reserved. 4 months, order did not. Then it was listed one fine morning. RP told me, sir, it is listed again. I said, okay, probably for pronouncement. He said, no, sir, it is not under pronouncement, it is for clarification. I said, all right. I appeared, in fact, I was in the US, I appeared from there. He said, Mr. Mutija, whatever you argued, we noted down in a register. That register is lost. And you argue again. I said, Bharat, I have to argue virtually now. He said, all right, you argue from there only, we'll give you time, whenever you want. So, the argument kept for 10 days later, I argued for 3 hours again. And they then vociferously noting down in the register. I hope I said this time they going to lose it. Order reserved. 3 months passed. Order did not. After 4th month, again they listed for clarification. They said, no, we wanted some clarification on these 2 issues. Can you, repeat what you said on 2-3 items? Again repeated for 1 hour. क्या करूं? अब बेचारा आरपी को मेरी फीस 3 बार देनी. Actually, he had to pay about that anyhow.
So that maybe another time visiting and recused from the matter, there is some conflict.
Another different thing. One and another interesting situation. Plan approval was also pending, filed by promoters. So they were eligible. It was a MSN. They were eligible. But here an avoidance application filed against them. So in the first hearing, when I appeared, the judge asked me, he said, Mr. Mutija, you are such a learned person, आप इतना भाषण देते हो, हमें भी दिया था कभी, when we became members. So now please tell us, you guide us, which application we should decide first, whether avoidance or plan. Because Venus recruiters say, we can decide avoidance later on. I said, well, that could be in a normal circumstances. Here the promoters, an application has been filed against the promoters. So according to me, this is an unclear judgment. Issue came before them. They said, we will decide on some other day. They mentioned that in that unclear judgment. I said, this is the day. He said, then do you have any other authority? I said, my lord will set the authority. So they were very happy once again. And they said, all right, so we will decide first avoidance application. So on my insistence, on my argument, they took up that application. So 3 hearings took place, 3 times I argued. You know what was the fate of that application? Rejected. No. Cash not available, 15 lakhs dismissed. Not even a single word on that. In that order. I can share that order with you. I can share that order, non-speak. Just 1 paragraph, application dismissed later on. And on the same day, now look at the second part. On the same day, plan also approved. Now RP can't file an appeal because he becomes front desk official. Our hands are tied. Had he given that judgment, RP could have filed before any fact. On the same day, application dismissed. And this, I'm not criticizing, I'm not saying they did it wrongly. They did it absolutely right in their own wisdom. But all I'm saying is, This is also happening.
Plan is in one case. Plan is clear. Sir, in one case, the plan was approved. And RP has been
But
substituted.
he liked the regards to you again.
Sir, if you like
अभी मेरा contempt करा दोगे.
No contempt. No. Supreme Court said sunlight is the best disinfectant. So let us expose.
Sir, in one matter, plan was approved. The RP was,
You suggest you know what has happened in another case also. It will be like any customer. I don't know about it. They're old enough.
No,
They're not criticizing.
No, until 1900s. Judicial.
Mr. Sebastian, personal insolvency case, all of you have seen. This case started. And I have very little information, but its liabilities were around 6,000. Personal liabilities, including guarantees and other things. Probably submitted a plan giving a few lakhs of rupees against such huge amounts. Plan came before the adjudicating authority in Delhi. I will share the judgment. I don't know why it is not available publicly in public domain. I've got a copy of that. One of the member has approved the plan. The other member, technical member, very boldly, she says, I do not agree. She has written a dissenting judgment.
How is that compensated without the consent of the creditors?
वो भी हो गया sir. Consent भी हो गया. So they say there was a manipulation there also. RP's conduct has been written in not one paragraph, 5 paragraphs. I think that's a very good lesson in order to read for a lesson for all of us. Right? Of course, we are not doing something wrong, but if we read it, we know what is happening in the market.
You know their mind.
And that judge, lady judge, has written in the order, and I've seen for the first time, even if you write a dissenting order, you generally don't blame the other member. Right? You will say, I differ with this, I differ. That's all. She has written 10 times that this was the objection raised by the creditors. The learned member has not dealt with it.
Comment me.
Not 1, 10 times.
Comment on that.
Then naturally, at the end, they said, since we are differing, it will be referred to the third member now, and they framed questions for the third member. So the first member who approved it, he framed 12 questions. You know what this lady did? He said, I don't agree with 12 questions, I will draft 5 more questions. The order itself is technical.
Problems are there, technical. They have Amaravati
Actually, why there are 2 members, naturally there has to be a difference of
some technical members are technically members.
Anyhow, whatever it may be, what is right, what is wrong, but I just brought it. It's a factual position.
What is the case that you are referring?
I'll share.
Situation, sir.
Yes, exactly.
Of a transactions you are discussing.
Right.
In one of the cases, the resolution plan was approved. The buffet application is pending. After the approval of plan, obviously resolution applicant is substituted with the RP.
Right.
Once the substituted application has been approved, the substituted member comes and says that I want to withdraw the application. The NCLT, without asking any question, allowed the withdrawal. Dismissed as
Actually, in this case also, the case which I did was, there also the COC put pressure on this RP to withdraw. He came to me and took my advice. I said, once you have filed it, if you withdraw it, you will be in trouble. Don't do that. Let them, you tell them that you come and file. If it is dismissed, it is dismissed. That is what happened. So he was also pressurized to withdraw. He did not withdraw. Okay. So now one more aspect. In section 19, who is to cooperate with RP? Personnel. Personnel includes employees, directors, and any person associated with the management of the company, right? So as an RP, please tell me, whenever you are doing an assignment, do you write to the suppliers also? Do you write to the service providers also? that please provide me the information? And if they don't cooperate, have you filed 19 against them? But there is no provision. In fact, I remember early days when we filed an application against the statutory auditor. Justice M.M. Kumar, who was the president at that time, he questioned and he told me, he said, Mr. Media, please tell me whether auditor is covered under 19. Why? I had to convince him. Right? Read it with 17, 2D and 19, auditor is covered. Now, IBBI is making, IBC bill, they are making a big change, which I already explained, and that is also a part of it. Now, what they are saying is, any person who has been a personnel of the corporate debtor or promoter or associated with the management of the corporate debtor, and the next sentence which they are adding is extremely crucial, or engaged in a contract for service. Wonderful words. I think this helps the armies also. Engaged in contract for service. That means if the company has engaged somebody for some service, this thing, so you can always ask now the details from him. This is very good, and that has been brought forward in CIRP also. Now let us look at the
who will put in non-cooperations in this CIRP process?
CIRP, supposing promoters don't cooperate, or somebody else, somebody
Still getting majority was there to decide.
Right.
And direct.
So here also they say 19 will apply here. Same adjudicating authority. And they will not decide, they'll keep the application pending for. I think that's happening.
Was it not there earlier, calling the auditors?
No, auditor was there. Now they're using a specific word, contract for service.
It comes to wait on the.
Contract of service and contract for service, these are two different terms. Contract of service means employees. Contract for service means outside vendors.
Any consultant or.
Any consultant, management consultant, even advocates will be covered. So now this is one of the important. Now let us look at what happens to the functions like the management of the affairs of the corporate debtor. Naturally, the management of the affairs will be kept with they continue to be vested with the board of directors. So that's section 17(1), which used to say that the powers of the board of directors shall stand suspended and shall vest in the IRP. It is not going to happen now, right? And then of course, RP is supposed to attend all meetings of the board of directors, all meetings of the committees of the directors, and he shall have the right, this is very important, to reject any resolution. He has the right to reject any resolution passed in the meeting, and once he rejects that resolution shall not be approved.
My question is, do we call for the board meeting? Because the COC meetings are taken even by the resolution.
So COC
including agenda preparation.
Correct.
Whether in the case of board meeting agenda preparation.
Okay, the things are very clear. The powers of the board of directors are not suspended. So therefore, the board meetings will be held as usual as they were being done earlier.
Powers are suspended, duties are not suspended.
No, even in this case, nothing is suspended.
Okay.
Even the powers are also not suspended.
Board meeting, how will it happen? Max. During this period.
Whatever.
Whatever, maybe convinced.
Maximum 2, yeah, but supposing it is extended, we don't know.
Companies Act.
Why? No, this overrides 238 overrides. That is it.
Suppose RP was not present in that board meeting. Some resolutions have been passed.
Still, he has got the power to reject.
After that,
Yes. Power of rejection is not dependent upon attendance. It may or may not appear, but the moment he says this will not be passed, then it cannot be approved. It has to be rejected. So you have got a kind of a veto power.
Yes, to give reasons.
Naturally. Yeah, naturally. In fact,
because we are saying RP attend all.
in fact, it is also mentioned subject to conditions as may be specified. So regulation bhi aayega. So not the routine resolution, maybe some important resolutions which will do. Okay.
Sitting fees is part of CR expenses. Then board we are insisting to attend the meeting. Even company secretary salary also.
No, salary of all employees, all the company is running.
Sitting fees was never arranged in these 5 years because nobody directly itself not.
Now, of course, it will be a part of this because you see the company is a running company, directors are coming. Suppose there is an independent director. Why should he be penalized not being? That is all right. I don't think there should be any problem. Okay, so now let's go to the very important section of moratorium. I think we'll have some discussion on this. Now it says, during the CIRP, the RP may, the word is may, after obtaining approval of the committee of creditors, then he will make an application to the adjudicating authority for moratorium, and moratorium under section 14(1) and 3 only will apply. Subsection 2 will not apply. What is subsection 2? Essential goods and services. Okay. So essential goods and services doesn't apply here. 14(1), which is 4 clauses, and 14(3) shall apply mutatis mutandis. That is the word which has been used. Now here comes a slight problem. So approval, they have not mentioned what percentage. 66 or 51, nothing is mentioned. I am presuming 51. Why I am presuming? Because of section 21, subsection 8. And that is also equally applies to CIR. If no percentage is mentioned specifically, then 51% is required. That is what 21 subsection 8 says. So this is one which is very important. Now, RP, like they are also saying, RP may also file an application for moratorium before the constitution of the COC. Because here, the first subsection said he has to take approval of the COC. Naturally, the COC has to be there. But if he wants moratorium before the constitution of the COC, he can still take a call and he can say after obtaining the financial creditors approval. So now there is no COC, he will take the approval of the financial creditors. Here they mentioned 51%. So I don't know, from some places they are mentioning percentage, some places they are not mentioning certain percentage. So I think they need to really reconcile. Now look at this. This is very, very important. I think there is a drafting error. I read it for you. Subsection 2 says, where an application has been made in subsection 1, moratorium for the purposes referred to in subsection 1 shall commence from the date of application and continue in operation during the CIRP process period. So let us see what is the state of affairs. No automatic moratorium first. RP has not constituted COC. He can move an application after obtaining 51% from the financial institutions. Second situation, COC constituted. He takes the approval of COC, files an application. Now tell me, friends, from which date the moratorium should begin?
The date of filing of an application by the RP.
Here the application means that IAR
IA.
If it is to begin from the date of filing application, then why do you need approval of the EA? Supposing now law says, this is what the law says, it should begin from the date of application, filing of the application. Again, there may be a lot of disputes. You find it, application was not complete, registry rejects it. Does the moratorium begin or not? Anyway, those confusions apart. But assuming, now let's take another case. Application filed, adjudicating authority rejects it.
No moratorium.
But for interim period, some moratorium was there. Because the law says it will begin from the date of filing of the application.
Sir, like in the partial guarantee, moratorium expressly.
That is also going, sir.
That is going.
They are deleting in case of personal guarantors.
Not there in the bill.
This is not interim moratorium, sir. We are talking about actual moratorium. Here, because the process has already started. But here, what is the purpose of going to the adjudicating authority if RP has to decide and move an application and the moratorium has to start from filing of the application?
No, sir.
Then adjudicating authority approval is not required. Then why do you need that?
Because debtor knows when I filed an application before the NCLT for asking the moratorium. If something happened, the asset, then it should be protected. No,
You mean to say from date of the order of NCL?
No, the third point is COC takes a call on 1st January. Application filed on 15 January. Should it begin from 1st January or 15 January? COC already taken a call, passed a resolution. Debtor should know now, if I go by your logic. So if you are making filing of the application before adjudicating authority mandatory to begin, please wait for their approval then.
It should be approved of the adjudicating.
It should be, logically speaking, it looks like that, but at the end of the day, it is not like this.
In the virtual application only, we should ask for this way.
So moratorium commences from the date of application, date of filing of the application, right? Not from the date of approval of the adjudicating authority. But it says, and the word is very interesting, adjudicating authority may confirm.
Exposed factor.
May or may not confirm. So may not. If it is satisfied, then moratorium is required for proper and efficient conduct of the CIR. अरे भाई आरपी को ही दे देते ना power to decide, और वैसे भी I think they should have done it also, isn't it? Anyhow, so this is another interesting thing, and then another public announcement is required to be made at this stage. RP will now make a public announcement and will say, I have moved an application for moratorium. That is also mentioned there. And he will also publish another public announcement that if and when the adjudicating authority rejects that application. No, that's not when it's a rejection. So first is for the invitation of claim, second is when I move an application for a moratorium, and third, when my application is rejected. So 3 public announcements to be made. So you wanted to make it cost effective. Now you are incurring more costs, isn't it? Okay, so 58H, I think most of it we have done. For conversion, 4 circumstances are there. No resolution plan, corporate debtor fails to cooperate, plan rejected, or COC decides to convert. So 4 situations are there. Cancel stage and other thing, I think we have already discussed on that. So I'm just skipping that. Now the next one is the very important, which is withdrawal. Withdrawal is very simple. 90% COC should approve. This is in line with section 12. But here comes a very interesting change. That change is also coming in 12A, and that change is also now coming in CIRP, which has been brought in line. Now, withdrawal, because there was a confusion, till what time the withdrawal should be allowed. Plans were approved and withdrawal applications were being filed even after that, isn't it? So now the stage of withdrawal of the plan has been correctly mentioned in the IBC bill now, or the CIRP also, and of course CIRP. Now it says the process cannot be withdrawn before the constitution of the COC. So now it is a must. So probably they will also amending regulation 20A after this. And 2, after the first invitation for submission of the resolution plan, the application cannot be withdrawn. So now they are restricted the time period. Constitution of the COC up to the first invitation of submission of resolution, RFR. Typically RFR, not the EOF. It is RFR. So that is it. So this is very, very important. Okay. And on withdrawal application on timeline, please don't laugh. They say adjudicating authority will decide in 14 days.
It's not the going seven.
Is that proposed?
And they say you will give reasons in writing if you don't pass. Okay, so now let's come down to this is very important. The 58J. What is the percentage with which the COC may approve? 66% same. And they have to be in conformity with section 30, section 31, all those sections which are there, they have been made applicable as it is. And in the last section, which is 58K, my dear friends, now here, these are the sections you can read on your screen, 21, 24, 25A, that is for class of creditors, then from 26 to 28A, which is a new section coming up now, 29, 32, 32A, we already know, and 43 to 51, and 66 also, they will continue to apply. So all those provisions of CIRP will also be applied there. Like COC will be constituted in accordance with 21, meetings will be conducted in accordance with 24, And all those sections will be typically be there. Okay, so these are the provisions which are relating to CIIRP. Let me show you a few of the slides. What are the strengths of the CIRP? Well, as I mentioned, it is designed as a middle path between the CIRP and PPAC. Because in CIRP you lose control, and in CIRP promoters are allowed to retain the control, which may, I mean, this is typically for cooperation and easier access to records. But the only point is, if the promoters are not permitted to file the plan, will this be successful? No. That is a big question mark. It is a recipe for failure, my dear friends. Mark my words today. PPIRP failed because of these reasons and some other reasons. CIRP will also fail because of these reasons.
They are consistent. No, sir.
They are consistent.
One question. When
Yes,
you fight section 95 can be initiated by the bank.
Yeah, that is not private.
That is not allowed, then this will be successful.
No, that is also, that is allowed. That is an independent provision. That is an independent provision, right? Okay, so now the challenges are, so number one, it is dependent on the promoter's cooperation. Now that is what it is a problem which is there. In CIRP, we have felt that promoters are not cooperating. Here we are presuming that they will cooperate. I'm not too sure. Number two, default disputes and litigation risks, because those litigation risks are there. Typically in this case also, creditors believe in default, right? The process begins with, oh, you have committed a default. Whether I have committed a default or not, who are you to decide? Let the court decide. But the court comes in much later, and then they will say void ab initio. So that is another problematic situation. I think it is bound to give more litigation. Because now they will not go into CIRP, they will say, let us wait for Supreme Court decision. Adjudicating authority will wait, and Supreme Court decision, you know, just read the recent decisions of Supreme Court. You know when those rates petitions or civil appeals were filed 2 years ago. Orders are coming today of Supreme Court. All those appeals were filed 2 years before. So it's not happening very quickly. Actually, Supreme Court is busy, so therefore they will take their own time. That is that. So approval complexities are there, 51%. Sounds very practical, but in a fragmented lending, so consortium lending, it is fine, but fragmented lending, then obtaining this may also become a very difficult, right? And then if one lender holds 51%, then the consent exercise is typically redundant. It's a brute majority, isn't it? And then 49% you are not bothered about any other person. The person into CIRP, that of course another issue. That means you are prolonging the CIRP now. So what is my idea? I'll just tell you, I think I'll not take much of the time. The present CIRP process, if you do 2 tracks in that, let the COC decide. Commercial wisdom. This promoter is a good promoter, has not committed a fraud. Let it remain in the management. And we'll continue the CIRP. With IP being a supervisory body, given whatever powers are there. He will attend board meetings, he will do everything. So at least what will happen is you will get your similar kind of a fees and you don't have to be bothered about these kind of daily issues. And if the COC feels that these promoters are unscrupulous, then it is fine. Then say, no, you will not be there, RP will take over from day one. So in CIRP itself, why can't we give 2 options? Make it 2 track. And then even in operational creditors started CIRP will also have these 2 options. Here, the operational creditors' rights are completely gone. Once the CIRP starts, finished. Operational creditors cannot start it. What is happening behind those, nobody knows, because this is going to give rise to a lot of manipulations. Backdoor arrangements being made, not with the bankers. We can't presume like public sector banks will make some kind of an arrangement, but you know who can do that. When the debts are assigned, what happens? Anything can happen. So those things will typically take place here. And it will be an easy cakewalk for each one of them. And then 51% deciding, 49% are dragged along. Well, you don't have say. We will decide.
51% RP and corporate debtor being together, they can run the show without going to the adjudicating authority only when the plan has been submitted to the adjudicating authority. Other than that, they no need to go to the adjudicating. These three are together. CD, RP, and 51%.
So you are saying that let us take out the adjudicating authority from the whole process.
Nothing there, you said.
It's a good suggestion.
Except Marco, they did not go to the.
Correct.
I don't need more to remark.
So avoid litigation also.
All three are in fix. All three are in fix. We go to the adjudicating authority only with the resolution plan.
That's like in voluntary liquidation. That's like in voluntary liquidation. I think these are few things which I wanted to bring into your notice in a critical manner. Without criticizing what is there, but at least we have understood what is wrong, what could be wrong in these things, and what suggestions we can make to the government to modify. According to me, if you just ask me, my last point is that this is typically speaking not going to be successful in the manner in which right now it is there. So I think something needs to be done in a serious manner to see that it does not fail just like India. Otherwise, we will be discussing the failure of or celebrating the failure of India. That's the other thing. So great friends, thank you so much for and I must thank IPA and all other associations who are attached with it for inviting me here. It was a real delight interacting with you. Thank you so much.
Thank you, sir. Thank you, Bhagija sir. Please answer. Thank you so much for your session. And it was worth it having it after lunch so that we could keep the participants also alive. Thank you so much. Alive and kicking.
Sweet tone, that is also.
That's a problem. Good. And because of SARS, you were not able to sleep. Sir, complaints on you.
Next time I'll come, I'll sing a lullaby.
So thank you so much, everyone. Thank you, sir. Thank you for your critical analysis of the entire section. So the critics goes to the section, appreciation goes to the speaker. Thank you so much. And thank you to FTCCI, their staff and the infrastructure that they have provided. Thank you so much, FTCCI. Thank you to IPNet, sir, for coordinating with us. Thank you to IPA, ICMAI, sir. Thank you for being there. And thank you to both of them for traveling from Bangalore and from Delhi. From Delhi. Yeah. You came to Delhi. Okay. Both of them from Delhi. Thank you so much, sir. Thank you for taking out time. And I thank all the HIPAA members, committee members, and all the lovely audience. Thank you so much for being there. May I request Narasimha Prasad, sir, to present a token of appreciation from HIPAA to Makija, sir, please.
And we'll have a group photo with everyone.
Yes. Yeah, and it has to be done quickly because this hall is booked for another seminar. People are very excited.
One or two definitely the last one. If you can put in a small document.
Yes. I request all of you, in case you have any suggestions or comments, anything, you can please write to us or post it in our group, HIPAA group, IPNet group, wherever, and we will consolidate it.
What we'll do is, in IPNet, we'll create a form, right? And you can submit that form with your comments. Just my request is please go through section 58A to 58K. Those who are company secretaries, 58A, company like 56, public deposits.
I request all of you to quickly assemble for a photograph.
Everyone should come here. I have a picture.
Sir, all of you can say. Once again requesting all of you, if you have not signed your attendance sheet, please be ensured you will not get your CP hours. And please leave the feedback form on your table so we'll collect it. We look forward to see you again. Thank you. Please take care of your belongings because this hall is going to be used by others now. We will not be able to locate your bed. All of you, please join us in the IT also. Sorry, IT is there. Yeah, please join us. Yeah, IT is
ల్యాండ్మార్క్ క్వశ్చన్స్ అని వచ్చిన చేస్తున్నా దాని
సెకండ్ ఫ్లోర్ గ్రౌండ్ సురాణ దగ్గర సురాణ మూల కాదన్నా వన్ ఎకరా తెలుసా ఇది ఓకే కదా
కొత్తగా ఒకవేళ పోతే ఉన్నాయి
వదిలేసి పెట్టినా